Yes. Twenty-three. You are okay. You are Misra. Okay. On the prayer of Mr. P. Hazrika, learned counsel for the petitioner. List this matter after 2 weeks. Hmm. 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 No, Tuesday not possible. Huh? What is the matter? We'll take it up today in that case.
Lordship, the senior counsel is engaged in this matter. He is having some difficulty today, Lordship. Lordship,
And on the ground that Mr. M.K. Chaudhary, learned senior counsel, has some. Huh?
On behalf of respond number 8, senior counsel is also appearing, Lordship. Lordship.
On the ground that who is senior counsel?
K.N. Chaudhary.
Yes, Mr. K.N. Chaudhary has some personal difficulty today. I'm a so and so learned counsel for the petitioner, the respondent. Number 8.
8, Lordship.
Press for listing of the matter after 2 weeks. Huh?
It may be 6 months.
Please stop. Prayer not being objected to by learned counsel for the petitioner. Let this matter be listed after 2 weeks. 2 weeks. It's very difficult. Next Tuesday, there will be matter again.
Then 16 minus.
Huh? We'll see after 2 weeks. List after 2 weeks on appropriate date.
Well, the Becky wants to listing case in admission column 2019 matters.
Why?
Well, next week, well, because revenue boards, their appellant's name is deleted. So they have filed a repetition. My lord, now case is pending there for hearing. So this may be next week. If you can have
After
that.
2 weeks.
Date may be given.
After 2 weeks. Huh?
Lawsuit, in this case, lawsuit, due to the changes, we are appearing for the first time lawsuit. So lawsuit, some accommodation lawsuit. I have one instruction is there lawsuit. That instruction says that lawsuit, the claim period is already over lawsuit. And
Have you filed the affidavit?
lawsuit, it is as per the records is not filed lawsuit.
It's 2019 matter.
19 matter.
There was lawsuit for the first time we appeared due to changes lawsuit.
Earlier, they have been taking time for filing affidavit also. In this matter, what happened? My claim application was rejected by the state level committee on the ground of comparing the production with the investment, and that is not the,
Which is not a requirement
not
under the
requirement.
policy.
Exactly.
What is the requirement under the policy?
Policy only says that if I make an expansion where I make a additional investment of plant and machinery up to 25%, so that enough is for considering the claim. Once they find it that I have made an investment of 25% and subsequent to that, they have to clear my subsidy. But what they have done is they have compared my production 2 years and 1 year before investment and 2 years and 1 year after investment and finding that there is no substantial increment. Now, that is a perception of an individual that there is no guideline or.
No, what he has said is there is a claim, delay in claiming the subsidy.
No, now they are saying that claim is over because it's a claim of 2000 lordship.
When lawsuit
And you
DTPT,
file an affidavit.
DTPT
in that
guidelines,
case.
lost.
Heard, Mr.
Dr. A.T.O.D. lordship.
A.T.O.D. Counsel for the petitioner. We'll grant them some time to file affidavit.
Lordship.
although matter relates, writ petition is pending since 2019. Mr. K. Gogoi, on the prayer of Mr. K. Gogoi, learned
Additional senior government.
additional senior government advocate for the state, who submits that. No, on the prayer of so and so. Not on the prayer. Mr. K. Gogoi, learned so and so, submits that is appearing for the first time in this matter, for which he prays for listing of the matter after 2 weeks. Next para. The considering that the matter is pending since 2019, prayer for adjournment is allowed, subject to filing of affidavit on or before the next date. This after 2 weeks.
Item 2. Thank you, Your Lordship. Lordship may pass over this matter for time being. My senior is on her way.
Why?
Lordship, let the matter come any other day, Lordship. I have not gone for it, Lordship. Say industries, commerce matter, Lordship.
Lordship, just for some time. She is about to reach my senior and say, yeah. She's about to reach. Only for some time, Your Lordship. Time being.
No, he's not ready. We'll adjourn it.
After a week, Lordship, after a week.
What is the matter?
Regarding subsidy, that part,
Same.
central government subsidy part.
You filed the affidavit here.
Here, affidavit is there, Lordship.
Okay, next week,
Lordship.
if affidavit is there. What do you say?
I'll leave it to Your Lordship.
Who's
She's
your
about to
senior?
reach. She's the downstairs. She's
After some time.
Please, Lordship, regarding non-payment of contractual bills, Lordship,
Yes.
the respondent PWD has taken time for instructions. Earlier, Mr. B. Gogoi appeared in this matter, Lordship. The matter pertains to 2001. My claim is pending since then. And
Yes,
accident
where's
was-
PWD? Where's the admission?
Lordship may come to page 62, annexure 15.
Reply.
Lordship.
Notice of section. PWD.
Lordship, after some time, I'll inform the PWD.
Will dispose of the matter because it was proposal for demand has been sent in the year 2021.
Right.
Will dispose of. After some time, we'll dispose of.
Item 4, Lordship, so for the time being.
Huh?
Item 4, pass over for the time being.
Why? What is there?
Lordship, that's also matter pertains to the subsidy. My senior Dr. BP Todi will be appearing in this matter, Lordship.
Who is appearing for other side?
Central Government Council.
If we start,
Dev Chaudhary is appearing, Lordship.
if we start taking up the hearing matter, will not take up the admission. Time being. Pune. Yes, madam.
Yes.
I think they should not take that for last 12 years, last 13 years. It was filed in 2012. Since then, they have to fight and fight and fight.
It's
All
a
reports has
repetition of
all-
2000, it's a repetition of 2021 lordship.
But the issue is.
Earlier set of council elevated to the debt side lordship, so we are coming that
does
side
not mean
lordship,
my lord, from
and
since
we have to go
Earlier
to this.
repetition, first repetition was filed in.
Otherwise,
12.
lordship
It was
here,
allowed.
here, our part
Let me
lordship.
tell the history. I am the petitioner. In 2012,
Good.
first repetition was filed. Then the repetition was allowed. Not only this, 4-5 repetitions together. They went for appeal. Appeal has reverted it to rehear again. Again, rehear it was allowed. That is reported also. Thereafter, again they went for appeal.
Appeal
So
was
that has
dismissed.
gone.
Appeal was dismissed.
Huh?
Appeal was dismissed.
Appeal was dismissed.
Now what do you want?
Thereafter, what they are making the practice, they have given me less money than the approved one. The recommended amount they have not given. Again, I have to file. And from 2012, they have received the money in 21 also. After fighting for so many years, after filing contempt, this, that. And my lord, thereafter also punishing the entrepreneurs who are giving employment, punishing the industries, they have given lesser amount. Instead of recommended amount was 1 crore 48 lakhs. They have given me 1 crore 14 lakhs. So they have to come again because for last 13 years they are before the court only. So
you want that balance amount.
3-4 months judgment was reserved. The judgment we could not get. Then my lord again it was fixed for rehearing. So written argument is first I will place the written argument.
It's okay.
So that your lordship will be convenient to the facts of the case.
So
It is there, my lord.
So next week.
Why, my lord? Earlier,
No, he said
earlier,
he has been
last
engaged
occasion,
today.
my lord, last occasion, court was not there giving time, but my lord, for their convenience, I have given a longer time. So each day they will take time. Because of their preparation of the case, I have given more than 2 weeks. 3 weeks. So, my lord, they should have prepared only one brief. It is very simple, including written argument is in the file.
We are
So
not
that is
dealing with
not-
lordship 1 week. We are dealing with more than 100 weeks per day
But
lordship.
that does not mean.
Per day lordship. Otherwise,
In the
lordship,
High Court.
otherwise,
For 13 years.
Mr. Gogoi, that cannot be a ground. That you have to manage.
lordship,
Exactly.
I am not saying that
That
it's a
you
ground
have
lordship.
that you have to manage.
Senior counsel has pointed out, that's why I reverted lordship.
Yes.
Otherwise, lordship,
For
otherwise,
13
lordship,
years,
if even emergency.
Okay, no further adjournment next week.
Lord,
Next week, my lord, next Tuesday, let it be.
Any day,
Next
next-
Tuesday.
lordship.
Next Tuesday, my
In
lord.
that case, we'll list it for hearing. We'll admit and list for hearing.
No, my lord.
Tuesday.
Then again, hearing will.
No, on
hearing-
Tuesday we'll hear.
No.
No, we'll hear the matter on next Tuesday.
Next week for admission hearing.
No. Tuesday where we just
No,
the
my lord.
matters are
Fixed-
fixed matters and the
Case is also fixed. That is, my lord, for admission hearing. So this when we, thoroughly to not reach, the same story will continue.
and MS NCK learned counsel for the petition
Yes,
and
yes,
Mr.
my
K.
lord.
Gogoi learned additional senior government advocate for this respondents.
9,
Police term next.
9, 9.
As agreed to by learned counsel for the parliament, let this matter be listed on 9th.
9
Also close.
for admission hearing.
It's Tuesday.
Tuesday, yes.
Tuesday is the hearing day, so
Yes,
better
sir.
admit and hear the matter. Finally,
No, my lord, please.
admission we
My lord, that does not.
admission we madam we admission column we cannot give you a guarantee. If it is admitted, we'll take it up.
Yes, also may fix,
Okay.
my lord, on admission hearing, so that it can.
Admission
be
hearing, huh?
stopped. Yes.
Okay.
Otherwise, my lord, hearing matter, my lord, does not reach. Wait for 4 o'clock, then my lord does not reach.
You kindly witness today. We'll finish the hearing matter. The hearing matter will be finished today.
Under court, my lord, another matter is there, bench to matter, it has
Anyway.
never reached, my lord. Suffer error. Oblige, my lord.
No, this is a matter, my lord, for blacklisting. My lord, I was supposed to file my affidavit. I have got a request from the authorities, my lord, praying for further 7 days time, my lord.
Sufficient time has been granted, my lord. On the last occasion, my lord, honorable court granted them time and fixing the date, my lord, on,
The comprehension was,
they were directed to file it on 12,
blacklisted for how many years?
3 years,
3 years.
3 years, my lord.
Okay.
On Friday, my lord, will consider it, or on Thursday, my lord, there's a hearing day. Before that, I will file my affidavit. I will try to file it by Friday of this week itself.
What was the default?
Well, the supply of the medicine, well, they have granted extension after the shortage. Thereafter, they have issued fresh orders.
Blacklisting you.
Like, no, fresh orders has been issued. Then, my lord, one day, my lord, they have issued the thing order. The shortage has nothing to do, my lord. Shortage only for one. Then several, my lord.
The authorities in the helm of affairs may not be happy with you.
My lord.
Essential medicines, my lord, defaulted in my lord supplying essential medicine.
Okay.
On Friday, I thought has
Friday.
coming week, yes.
My lord,
Next Friday.
no, yes, my lord. Maybe, my lord. It may fix on 16th, my lord.
16th.
16th, but let them file it this Friday.
Fine. I will
And
try-
we shall,
try my best.
if necessary, we shall file a reply.
I heard Mr. James Learned Senior Counsel assisted by Mr. Learned Counsel for the petitioner. Although, no. Mr. B. Gogoi, Learned Additional Advocate General, phase 4 is granted time to file affidavit. It granted a week's
On 5th, they will file.
a week's time to file affidavit.
On 5th, my lord, that may be.
We'll say, praise the Lord. No, phrase 4 and granted a week's time to file affidavit.
Fine.
1 week will say, since we are fixing the matter,
No, I will try to file it by 8th, my lord. Latest by 8th. But they will get the time.
as agreed to by Learned Counsel for the party, let this matter this time 16.
16th, my lord.
16/09.
If necessary, my lord, we can file the reply.
It's up to you. Yes, Gogoi. Mr. Gogoi. Page 62.
My lord.
Can you see page? 2021, you have processed
My lord.
the demand.
Well, I have got a detailed parawise comment, my lord, on. I would like to file
Say,
fraud
what is there?
Plus,
Simply go to reply
yes, one para only.
reply to page 62.
Now, as per our record, my lord, the amount due is some 39 lakhs
Yes,
15,003.
that is their claim only.
My lord.
You will dispose of since it is admitted. You have processed it long time back, 2021.
That's it.
All right.
The claim is lordship along with 9% agency charge.
No,
There,
we'll-
my lord, there is a difficulty, my lord.
That will not.
May I submit?
If you are interested, we'll just give this
No,
amount.
only regarding this part only, my lord. So,
Right.
whereas, my lord, this 39 lakhs 15,000 is concerned. My lord, due to the long pending of the work and my lord, due to unavailability and encroachment, so and so, the work was abandoned. But my lord, we'll have to revalidate the entire process. Then only, my lord, it can be done. So, it will take some time.
No, when you have processed in 2001.
Lordship. No, in
Then-
fact, they have stated.
So that is your lookout. How can he be blamed? Once this is completed,
Incomplete bill, my lord.
yes,
So,
the
lordship-
outstanding amount for those stated unpaid bill is now so and so. The proposal
Lordship will-
demand to
Lordship
release
will
this.
record, my lord, whatever is there in para 6 of my instructions, my lord, that
Ah.
lordship will dispose it.
Yes,
And lordship may keep it as a part of the report. It will be
Ah.
there in the process.
heard Mr.
So, 8 only lordship.
To the Learned Counsel for the
Only one
petition.
para.
And Mr. B. Leonard, standing counsel or additional advocate?
Additional
Additional
counsel is there, I
advocate
can
for
inform.
this, but respondents. By filing this writ petition, the petitioner has prayed for direction to the respondents to release the admitted balance amount of rupees, admitted amount of rupees 39,15,003, along with 9% agency charges amounting to rupees 3,52,350. List of, so on account of what is the work? Execution of the, what is the work? Name of the work?
Lordship will find it annexure, sorry, para 3, Lordship.
Execution of
Work for flood damage repair of NH 151.
execution for work of flood damage repair on NH 151 for immediate repair from kilometer 002 so and so. Para 3, Karimganj Road under Silchar NH division in the state of Assam. List of. Next para. Petitioner who is company registered under the Companies Act, having its registered office at Ulubari, Guwahati. And head office at Devendranagar, Karimganj, Assam, was awarded the work for flood damage repair, so and so, same work, pursuant to the NIT dated 22/02/2010. List of. Mr. Eto, the learned counsel for the petitioner, submits that the on being submits that the petitioner has satisfactorily executed and completed the work for which a running bill accounts of part payment were made. Mr. However, the admitted remaining amount of rupees 39,15,003 has not been paid to the petitioner despite several approaches. Mr. Referring to the Mr. Todi, while referring to the reply to the Section 81 CPC notice by the Executive Engineer PWD Karimganj NH Division, submits that the authorities have clearly admitted the outstanding amount claimed by the petitioner. Therefore, it is incumbent upon the respondent authorities to release the outstanding amount admitted outstanding amount of rupees 39 so and so with 9%. What 9%? What charge?
Agency charges, Lordship.
9% agency charge. Mr. K. Gogol, learned B. Gogol, learned counsel, learned additional advocate general, while placing the instead placing the written instruction, submits that the amount of rupees 39 so and so claimed by petitioner, no doubt, is an admitted amount. List of. However, and admitted amount and a demand has already been placed before the appropriate authority for release of the amount. List of. However, while placing the demand of the was placing demand for payment after finalizing the works, particularly Group 1 and Group 2, in incomplete stages due to unavailability and encroachment of free land for construction of drain, the validity of works was lapsed and needed to be revalidated. List of. Since the proposal for since the demand for since the revalidation has not been done.
Yes, madam.
And the proposal for payment has not been approved. No, since the demand for revalidation, this is the issue of revalidation has not been approved, and the demand being not sanctioned, the amount would not be paid to the petitioner. Mr. Therefore, he submits that the work needs to be revalidated, and until the time revalidated and the exact amount entitled to the petitioner has to be worked out. Therefore, some time would be required to have the revalidation and place the proposal of demand for the fund. Mr. I've considered the submissions of learned counsel to the parties, also peruse the materials placed on record. Admittedly, the executive engineer, PWD Karimganj NH division, by the communication dated 23/12/2021, has, in clear terms, has stated that the outstanding amount for the works executed by the petitioner, which remains unpaid bill, is rupees 39 so and so, 15 so and so, which is pending for payment to the contractor. The proposal of demand to release the outstanding amount was sent to the sanctioning authority by letter dated 21/02/2015 and dated 21/12/2021. It is also a categorically stated that as soon as the amount is released, the same shall be paid to the contractor. Although, by the instruction is noted above. The stand of the petitioner is to the effect that the proposal for re-verification of the work, revalidation of the work were initiated and submitted to the competent authority for its approval. However, no approval has been granted as on today. And the proposal for, as well as no proposal, no demand, no proposal for demand has also not been approved, which indicates that for want of revalidation and the paucity of fund, the petitioner, the admitted amount of the petitioner could not be paid. Having considered above, and also considering that the petitioner, the respondent authorities have executed and completed the works awarded to the awarded, and the only the only grant for non-release of the admitted outstanding amount is for want of revalidation and paucity of time, a paucity of the fund. I'm of the consider that the state would extend to the effect that the certain revalidation of the work and the paucity of fund, which has caused hurdles to the payment of the admitted amount to the petitioner, cannot be a justified ground. The requirement of revalidation would be is the job of the authorities, and the sanctioning of the fund, as well as the sanctioning fund is equally to be made by the respondent authorities, which cannot be a ground to which cannot be ground to refuse the payment of the admitted outstanding amount. The amount of the ground of the non-availability of fund, non-availability or the paucity of should not be a reason to stop. Just delay. The petitioner should not be made suffer due to availability of fund or requirement of revalidation, unless the amount claimed by the petitioner is disputed. Next paragraph. In view of the above, and considering that the claim of the petitioner is admitted is an admitted amount, it would not be appropriate to deny the payment of the said amount to the petitioner. Thus, the respondent authorities are incumbent upon to release the payment of the petitioner as the amount claimed is an admitted one. Accordingly, I deem it appropriate to dispose of the petition with the direction for the respondent authorities to release the payment of the outstanding admitted amount of rupees so and so, so and so. Within it, without 9%, without 9%, please stop, please stop. Within a period of 4 months.
4 months, it will be
4 months from the date of receipt of the certified copy of this order. Please stop. It is made clear that the petitioner, they claim for 9%. What charge?
Agency charges.
Agency charges is rejected in view of the fact that the in view of the fact that it has to be debited to the state government's accounts. He's not entitled for 9%.
No.
Why you are claiming?
I am entitled to 9% also.
He said you are not entitled. It has to be debited in the exchequer, government accounts.
Yes, it has to be debited, so I'll get it, Lordship. Exchequer.
No, it's in the last para, it has been settled.
Yes.
Regarding that part, Lordship will say, my lord, only that 9%, but authority will verify and, my lord.
Yes, authority may consider that part, Lordship.
Rest of the admissible amount that will be paid. Only for 9%.
You are entitled for agency charge. What do you say?
But that, my lord, he'll have to show, my lord.
Lordship may come to page 59 once. Whole liability, they have considered my principal amount plus additional charges as 9%, page 59.
No, please stop.
So that may be considered by the authorities.
That may be considered.
So far as the claim for 9% agency charge by the petitioner, the respondent authorities shall verify.
Yes, sir.
Examine and verify as to whether
contract.
the petitioner is entitled for
In terms of the contract. In terms of the contract agreement.
Please stop. In terms of the contract agreement, if it is found to be entitled to be paid to the petitioner, same also be released.
Lordship.
Unless it is not, what do we call?
Not find entitled to.
Unless it is not required to be paid under the contract.
Under the
contract agreement.
Under the
the work has not been completed by the petitioner because of want of encroachment free land. It could not be completed. Also said completed.
We'll say that executed.
Executed, yes. For the portion he has executed.
But then why you have admitted?
No, admitted, my lord, because the encroachment free land
39 lakhs which he is claimed,
yes, only for
though
the
he has not been completed, he is entitled.
He is entitled.
For the work which is.
That is for executed work.
Or she will say executed work.
Then we'll say executed, not completed.
Yes, sir.
Executed work.
Completion word should be deleted. Very much.
Obliged. So that part of the report will
the instruction placed by the written instruction placed by the learned additional advocate general in the form of para-wise
yes, sir.
be kept on record.
I will like.
Much obliged.
My lord, may I please, sir?
Yes.
My lord, this is a scheme, my lord, provided by the Government of India, a special purpose tea fund scheme, my lord,
Hmm.
which lord you also will find at page 23.
23. Yes.
Page 20, it starts from page 24, my lord. May read, my lord.
Hmm.
Modalities for implementation of tea development and promotion scheme during 12 plans. The Government of India has conveyed its approval for the tea board's scheme, tea development and promotion scheme for implementation during 12 5-year plan, 12 to 17, file data number so and so dated 12/12/2014. The scheme has the following 7 major components covering the broad areas of tea board's operation, plantation development, quality upgradation, tea production, product diversification, market promotion, research and development, welfare, tea garden, workforce, small growers, development program for tea regulation, overall protection, growth, sustenance of the Indian teas. In fact, my lord, Lordship is aware that my lord, various schemes are floated by the Government of India for promotion of the industries. Then Lordship may kindly come this component 1, plantation development. But out of these 7, my lord, because so the petition is concerned, they fall on the component 1. Next para Lordship may kindly see the above component primarily comprises of extending subsidy, financial incentive grant in aid for various activities carried out by different stakeholders. Tea garden, stakeholders for improving the production, productivity, and quality of tea in India, and promotion of Indian tea in the international market and research and development. Then, my lordship may kindly come. Next, implementation and monitoring of the project. Then, director in the development will be the nodal officer for implementation of the component 1. Next, my lordship may kindly come to page 25, my lord. Clause 9. The tea board reserves the right to amend, amplify, or abrogate in its discretion any of the terms and conditions of the scheme without notice, as it may consider necessary for efficient execution of the scheme and fulfillment of its objectives. But they have the right, my lord. In fact, my lord, Lordship is aware, my lord, even after MP Sugal Motil poison path, my lord, the number of judgments came, my lord, the government in the public interest may amend. This is Lordship aware, my lord. When Gottlieb Clip, other judgments are there, I am not on that, my lord, but this is the purpose, my lord, that they can amend subsequent. But in this case, they never amended, nor, my lord, any of the changes were there. But then Lordship may kindly come to page 26. Page 26, my lord, it's 1.1, replacement, planting, rejuvenation of the old tea bushes. Then, my lord, next, my lord, clause B, eligibility conditions generally common for all 5 components. This is, my lord, and next page 27, Lordship may kindly come to clause 7. For carrying out pre-approval instructions in time, the applicants will submit their application to the nearest field office of the tea board at least 30 days before the commencement of any field activity, that is uprooting, rejuvenation, pruning, planting, and uprooting procurement and equipment. In case of replanting, rejuvenation, pruning, and consolidation, extension, planting, replacement, planting, irrigation, mechanization, applications submitted after commencement of the field work will not be considered and will be summarily rejected. That means, before commencing the work, when application has to be submitted, prior
at least before 30 days.
30 days prior to, commencement of the work.
What is your work?
Uprooting and replanting.
Uprooting.
And replanting. And for availing the under the scheme, the subsidy, the provisions, the prior 30 days prior to permission has to obtain. Otherwise, if after 30 days, after commencement, then they are not, one is not eligible to.
Yes.
So for the petition is concerned, because we have applied prior to 30 in conformity with this scheme.
When did you apply?
That, Lordship, I am coming to that, Then, if Lordship, bear with me, clause 8, that says, after NOC, my lord, because NOC, my lord, it is important, my lord, so my lord, if it permits, my lord, I read, my lord. Field operations, uprooting, rejuvenation, pruning, extension, plantation uprooting in case of replanting, rejuvenation, pruning, and consolidation, replacement planting, extension planting.
It's okay, when
Shall be commenced by the applicants only after receiving the NOC. But NOC has to be obtained only after NOC, my lord, then only, my lord, one can commence the work. As per the clause 8. So, my lord, without NOC, receiving the NOC by the, my lord, concerned authority, my lord, they cannot start the work. So
when did you apply?
Yeah, my lord, I'm coming to that, my lord.
That is the issue only.
Yes, my lord. Correct, my lord.
Is not it?
I'm obliged, my lord.
Let us not go into it, is not necessary.
I'm obliged, my lord. My lord, just I meant to throw the light on the whole.
Yes. I'm enlightened.
But I'm
to be frank, I'm enlightened.
I'm obliged, my lord.
I have never come across this.
My work is very easy, my lord. Become very easy, my lord.
Yes.
My lord, the lordship may kindly come to page 54.
54.
Application, that was, my lord, 12/15. What the lordship vote is, my lord, page 54.
54.
Yes, my lord.
Development office.
Yes, my lord.
That is
under the T board's TDPS scheme for plantation development, uprooting, replanting of our garden sections 12 and 14 in prescribing form by the T board necessary documents required, the checklist attached. But 12, 14 is, my lord, the section is for garden sections, my lord. 12 comprises certain hectares land, and 14 also hectares comprises certain hectares of land, but which lordship find it is 55. Page 55, my lord.
No, this is received. It was received on 30/12. Although the application is of 12/12.
Yes, sir. Yes, sir. 38, my lord.
So we'll take it at 35.
Yes, my lord. 12 also.
38.
Yes, my lord. It was received by duly received on 30th December 2015.
Though you have mentioned 12/12.
Yes, my lord. Quite true, my lord.
Yes.
Then my lordship may kindly come next page, my lord, which is a letter dated 29 January 2016, issued by the T board. Annex 3, page 55. May read, my lord. With subject special purpose T fund scheme, uprooting, replanting, accounting 15/16. With reference to your application dated 38/12/2015 and subsequent inspection dated 28 January 2016, undertaken by this office, I am to inform you that there is no objection to your commencing uprooting operations of 19.94 hectare under Board of Special Purpose T Fund Scheme pertaining to uprooting, replanting activities at your own risk, subject to your fulfillment of all the terms and conditions of the said scheme in areas noted below. Section 12 that comprises 11.89 hectares area, and section 14 that 8.05 hectares. It may also be noted that this is being issued with the objective to enable you to commence and complete the field work within your time schedule without any financial commitment on the part of the T board at this stage. At that stage, at this financial commitment, they don't have. That means, all the money has to be spent by the tea garden owners, and subsequently subsidy has to be obtained as per the scheme. But this is the plain language of the letter that without any financial commitment on the part of the tea board at this stage.
This is what? This is a kind of it's an NOC.
It is NOC, my lord. It is NOC because, my lord, as per the scheme, NOC has to be obtained. After the inspection, they issue NOC. And while issuing NOC, this is the NOC they have issued. And while issuing NOC, my lord, one line they have added that, my lord, is without the financial risks at this stage. That means the plain understanding that, my lord, the money has to be spent by every scheme. First, the, my lord, investors to invest. Then subsequently, my lord, when it is fulfilled as per the conditions laid down in the scheme, then one of the schemes, the amount is reimbursed, subsidy. Lordship is aware about the fact. Then my lordship may kindly come to next page, 56. 15/16, my lord, the letter was issued, NOC was issued on 29/1/2016
Then next page, my lord. This is very important. 9/7/2021.
Yes.
About 5 years thereafter, my lord.
Hmm.
My lord, letter was issued to the petitioner with reference to your application received by board's field office on 30th December 2015 on the above mentioned subject. I am directed to inform you that your case is not found to be eligible for financial assistance because of the following reasons. That is reasons number 3, my lord. What is it? Uprooting not completed within the financial year in which application was submitted, that is 31st March 2016.
Hmm.
In fact, as per the NOC, the work so for uprooting what was to be completed within the financial year 31st March 2016. That is the requirement. And so far the replanting is concerned, that he has to within 3 years thereafter, 3 years time further. But that is not dispute, subject matter of dispute. Dispute is that within 31st March, the uprooting has to be completed. Then notice may kindly come to next page, But next page, page 57. Uprooting in section 12.
So this is the issue, uprooting not completed within the financial year in which application was submitted.
In fact, the 2016 was the period. Within March 2016, the work has to be completed. That was the condition laid. Now,
Under the scheme.
Under the scheme. Then, the whole case lies here. That's why, I am emphasizing again and again on this issue, because whole case lies here only.
Yes.
Then, Lord may kindly come to page 57. This is the that uprooting, as I said, to 2 areas, area section 12 and 14. So 12 area, 11.89 hectare. Here, Lord will kindly see.
This is prepared by you.
Which one?
This is prepared by you.
Yes, prepared by us, but approved by them. But I am coming to their inspection also. There's no dispute. Dispute with regard to only one issue that I am coming to that, my lord. Then Lord will kindly see page 57. It starts from 15 February 2016. That number of bushes, my lord, on 15 February, 700 bushes was approved. On 1600. Then, it continues like that only. On every day, my lord, every day or after alternate day, the bushes were there, and then addition was also there. How many bushes had been, my lord, approved? That cumulative figure has been given on the right side, my lord. First 700, then 1600. 7 plus 1600 comes to 2360.
So, admittedly, you have not completed by 31st.
No. I am coming to that, my lord. That is the whole case. I am coming to that, my lord. We have completed. Here, my lord, here the case.
Page 59. Page 59.
Yes, my lord. 59, I am coming to it. Now, my lord.
Last 13/4/2006.
My lord, what is that, my lord? In fact, my lord, for 1300 bushes, because it was wrongly, my lord, it was typographically, my lord, a clerical mistake was there. Only 1300 out of 46,000, 1300, my lord, instead of writing, my lord, 13.3, it was written by mistake, my lord, 13.4. But there, my lord.
So you have completed by 13.4.
No.
13.3.
13.3, but what happened, my lord? Because clerical mistake 13.4, but even, my lord, for 1300 bushes, my lord, then, my lord, Supreme Court, my lord, time and again said in subsidy matter, my lord, whether one has to be, my lord, pragmatic, liberal, or my lord, for one particular clerical mistake where the whole scheme can be, my lord, can be negated, my lord, where the subsidy under the scheme can be negated, my lord.
How do you say that it is a clerical mistake?
But we have stated, my lord, clerical mistake, how it is clerical mistake, my lord? Because petitioner also aware, and my lord, if you lordship kindly see the sequence, my lord, every day, my lord, there is uprooting, and thereafter, my lord, 34, my lord, 1 month, my lord, but there is a stoppage of 1 month, my lord, even under the, my lord, general understanding also, my lord, it is understood that cannot be, but still, let it be timing for, but presume that, but even, my lord,
there is a break of 1 month.
Yes, my lord, even, my lord, assuming.
You must be on holiday.
No, my lord, in fact, my lord, 31st, my lord, even, my lord, out of 46,000, 46,000 bushes, which was approved as per the provisional scheme, 46,000. whether, my lord, for 1300.
Anyway,
1300
sir, so as that this is a clerical mistake.
Yes, my lord. Yes, page 56, 61. Page 61. It was page 61. Lord may kindly come to page third para, my lord. Third parrot, you will clearly understand from the statement submitted by us that from the entire 8.05 hectares of section 14, 1300 bushes were sown uprooted on 13/4/2016. Balance total section was uprooted on 12/3/2016. The aforesaid 1300 bushes were also uprooted on 13/3/2016, but due to clerical error, inadvertently it has been sown as 13/4.
No, this is your statement. This is your letter.
Later,
How do you know that? How do we find out that this could be a clerical mistake?
but I'll come to it, my lord.
We just cannot infer.
What happened, my lord? If there is a, my lord, as per the built-in mechanism under the scheme, they have right to inspect. They have the inspection is there. Then also, my lord, was written that under this circumstance, we would earnestly request you to consider our request for modification in the change date of completion uprooting by sending your field inspector again for re-verification so that the proposal is not rejected only for small clerical error. My lord, in fact, my lord, because they have the first inspection, second inspection, they have the right. And they have their inspection also there. They have also inspected also. What inspection is there, my lord? They can also, this can be verified. From
This signature page 61, 13/4 is by whom? By them.
By them, my lord. I'm coming to them. I'm coming to them. If my lord, I'm coming to my lord. If you also permit me, I'm just this thing, my lord.
No, I just wanted to know. I'm curious to know this signature by whom?
My lord, I'm coming to them. In fact, my lord, what I meant, affidavit filed by them, Lord may kindly see. In their affidavit, my lord, they have enclosed in their affidavit, they have enclosed the inspection report. Which Lordship find their affidavit page 113. Affidavit filed by the keyboard.
113.
Page 113 was Lordship board. Affidavit, my lord. This will clear everything, my lord. Make it clear everything.
Yes.
My lord, my lord, special purpose tea fund scheme activity replantation. Name of the state, DUT state, the place so and so. Assessment year, accounting year 15/16. Date of inspection 18/3/2019. The undersigned have personally visited the above mentioned tea estate on the date stated above in order to verify the details uprooting replanting operation. I have inspected the area on the spot and have scrutinized the relevant records. The inspection was carried out in presence of the so-and-so manager of the tea company. Then, my lord, this is section 12. My lord, the last date of average section yielding. This was the, my lord, Lordship will kindly see. This is a commencement 21/3/2016 and completion 30/3/2016 and 21/4/2016, 30/4/2016. Then, my lord, what happened? Special remarks down below, my lord, at the bottom. A well decomposed organic hemi component 3 kg. This was the, my lord, requirement that we mentioned. Then Lordship may kindly to next.
So you see, this completion is 13/4/2016.
With regard to, my lord, only 1300 bushes, my lord, which we say it's a by mistake clerical, but my lord, now the case is, this is the case, whether, my lord, for a small clerical, let us see for a timing, my lord.
It is correct.
Correct. Let us be correct for timing. Correct.
Because you were for 1 month, you were in holiday. They were in holiday.
No, it is not there. But my lord, let us presume for timing, my lord. Even, my lord, suppose they say it is not clerical mistake, or my lord, we also, my lord, say that okay, let it be like that only. Suppose you don't correct it, but whether there is the case, my lord, whether for 1300 bushes out of 46,000 bushes, for one clerical mistake, the whole thing can be shut. That is not the scheme. The scheme is to be, my lord, Supreme Court in, my lord, in Markham Textiles case also, Supreme Court said followed by several, my lord, the number of judgments by this Honorable High Court, my lord. It said that, my lord, it should be, you know, not rigidly. It should be liberally has to be construed. And what is equitable? What is reasonable? I'm coming to these judgments also. I will place before Lordship, my lord, all the judgments. And it is constantly followed, my lord, in subsequent judgments, several judgments, my lord.
1300 bushes.
Yes, my lord, 1300 bushes out of my lord, 46,000 something, my lord. 46,360.
Isi ko deny करता हूँ clarity mistake है उसको deny करता हूँ deny करने से भी point तो वही है कि ये हमारे इसके तो हमारे report तुम check करता है तुम तो एक तो इसका cleaning है तो
And it was supposed to be completed by 2000,
but 35/3
2016.
Clarity mistake 31/4. It's only my lord, the mistake was with regard to the month. Exactly, my lord, and nothing more, nothing less. Now, my lord, even their report, my lord, I was referring to your lordship, my lord, their report.
Yes.
Up to page 114 of the affidavit, my lord, their affidavit.
1 and 3 is very clear that the completion is 13/4.
No, my lord, lordship will kindly see. Lordship will kindly see. But
And rehabilitation program 13/4.
my lordship will kindly see. Now,
Yes. Now come to 104.
104.
What is this?
104, the last, bottom line.
Hmm.
The work has been carried out satisfactorily in terms of the approval as conveyed in the T-Board's letter number so and so dated 29/1/2016, but which was the NOC, my lord. In case seed has been used, planting material, original seed challan should be enclosed with the good authentication of the matter. In fact, my lord, except, my lord, that so far the going by date mentioned by us, going by the date mentioned by us, they say that, my lord, it was 13/4/2016. Going by our my lord, record by the clerk, what to mention by the clerk.
So 114, what do you want to show?
My lord, why?
Saying that the
It is
work has been carried out
yes,
satisfactorily.
my lord, satisfactorily in conformity with the scheme. My lord, dates
In terms of the approval as conveyed in the so and so 29/1/2016, in case it is. Yes.
my lord, in fact, a attested copy of the survey map of the plot actually replanted, drawn by the government approved surveyor, duly indicating the area and the attached is also certified that the replantation has been carried out satisfactorily according to the conditions laid down in the replantation subsidy scheme, and the planting, shade, trace of drainage, etc. adequate. The sections mentioned also did actually carry the T under plucking, and none of the category abandoned T commencement uprooting of the center, because there's nothing, my lord, adverse found against us with regard to the compliance of the provisions required under the scheme, except the clerical mistake. Now, my lord, our case, why, my lord, approach before the honorable court? In fact, my lord, so far as the my lord, in fact, my lord, they have filed an affidavit. That affidavit also contains denying the position that, my lord, relying on the Calcutta High Court judgments. But I will also come to that, my lord. The facts are entirely different, completely facts. And my lord, not nowhere the facts are, my lord, not similar, but highly dissimilar. But even, my lord, they said this is the binding under Article 141. Perhaps, my lord, I will come to that also. Before that, my lord, I will come that Supreme Court what it said and subsequent judgments followed by Supreme Court judgment following various, my lord, judgments have been passed by the Honorable High Court, where it says that, well, how, my lord, the schemes floated by the central government are to be interpreted.
This scheme or some other scheme?
Schemes.
Any scheme.
Schemes. But when, my lord, the public subsidy schemes are floated by the government, central government.
So,
my lord, these have to be, my lord, in fact, my lord, these have the benevolent public purpose to be achieved, because when, my lord, when some benefits are granted.
Citation?
Citation, my lord, 2005-10 SCC 554. Under Secretary, Ministry of Industries and others.
Para?
Para 8, my lord. Para 8. Para 8.
Mark Jones.
This approach will be consistently approached, my lord, followed. This approach, Supreme Court, my lord, what is my lord, completely approached. Even, my lord, para 8, my lord, I'm reading, my lord. The scheme floated by the state, releasing grant of subsidy for industrial units to be set up in certain selected backward district areas, have a benevolent and public purpose to achieve.
Practical and pragmatic approach so is to achieve.
That is to promote the growth of industries in such district areas, which but for the state encouragement would continue to remain backward and the international investment would not be attracted in such areas. Such schemes have to be construed with practical and pragmatic approach so as to achieve and not to frustrate the purpose sought to be achieved.
Okay, sir.
Then, my lord, the benefit of the scheme ought to be allowed if
Okay, sir.
it can be done.
I've read it. I've read it, sir.
Yes, my lord. Last sentence, my lord, if you wrote, permit me.
Yes.
Only few sentences, my lord. The application should not be dealt with hyper-technical approach or in a pedantic manner. It should be an application filed before the cut-off date and the opportunity should be allowed to the applicant to cut the defects which they are not substantial nature or are capable of being cured so that the deserving units are not left out of the scheme. That, my lord, for clerical mistake, even, my lord, one question, my lord, I asked to myself. Even, my lord, it would have been, my lord, the substantial, my lord, the plantation, uprooting plantation was on April, 4 April, my lord. Then matter would have been different. Out of 46,700 some uprooting, my lord, for 1,300, my lord, which for one day, mentioned, my lord, for a month instead of March, which was it mentioned March, my lord, whether the whole thing can be shut the door, my lord. In my respect to submission, my lord, it is not the purpose, my lord, they cannot shut the door, my lord. They cannot shut the door, they cannot, entire scheme cannot, at best, what can do, my lord, what they can do at best. For 1,300, suppose they are very rigid, no, we don't want to consider 1,300. For 1,300 buses, my lord, they can proportionately, the 1,300 can be, my lord, taken care of, rejected, but entire, my lord, scheme, cannot be.
So far as the clerical mistake is concerned,
My lord.
I'm not convinced, this court is not convinced. Maybe you can infer that it was every day it was doing it, but how can there be a gap of 1 month? That I can presume and infer. But then I'm not convinced that it is a typical mistake. Clerical mistake. I'm not convinced. So far as the approach, this scheme, as you have, I mean, by the Supreme Court, that can be looked into. We can think about it. But you just say that even if there's a, I mean, delay or the completion, even if there's no clerical mistake, assuming that it is not a clerical mistake, it was completed on 13/4.
Yes, 13/4.
So that you may argue on that, but clerical mistake, I'm not convinced. There's nothing to show that it's clearly one after another is clearly written. The inspection team by the T-board is clearly completed on 13/04. So,
my lord, at the initial stage, my lord, I fairly submitted, even, my lord, assuming, not accepting, my lord, let us accept. Let's accept as it is, my lord. That in space of 13/3, not it's a 13/4. There is no clerical, they are not accepting it, but they are not convinced with our
that cannot be, according to you, that cannot be by applying the hyper-technical approach. It could not have rejected. It should have been, there should be a pragmatic and all.
Yes, my lord.
Since it is a scheme.
Yes, my lord. So for 1,300, my lord, buses, my lord, they can say that yes, 1,300 we reject. But more substantial, my lord, what is the percentage? If 46,000 and 1,300, percentage will be, I think 0.1 or something, whatever it may be. But for that, whether the entire scheme purpose.
But one thing, once, if you are relying on the scheme, what is provided in the scheme, it has to be equally followed.
No, in fact, my lord, so far, my lord,
suppose your claim, subsidy, whatever, assistance, your claim is under the scheme. And the scheme provides the guideline. I mean, what is to be done, how it is to be gone into.
My lord,
so once you are relying on the scheme, the guidelines provided therein has to be followed.
My lord, in fact, my lord,
If the requirement is to be completed in a certain period, if you have not done, how can you? I think
my lord, my submission like this.
yes.
So for the contextual matters are concerned, my lord, yes. If they want something in that NIT, my lord, it has to be followed in that manner only. No deviation, nothing, my lord. No reasonable, no reasonable, no my lord, equity, nothing. But what do we want? But so far
Because of this.
no, my lord. In fact, so far as the subsidy matters concerned, my lord. But is my lord what the apex court said?
That's what I'm saying. Because of this. Because of the judgment of this FX court.
No, subsequently followed also, my lord. It said that, my lord, even, my lord, what says, my lord? In fact,
Sir, I have understood.
but even, my lord, for a small mistake, my lord, the whole thing cannot be, my lord, negated. Suppose 1300, my lord, let us accept for time.
Agree.
Huh?
Agree. I agree to that.
My lord, obvious, my lord.
But then, when you are relying on the scheme, particular scheme, which provides for the how to go with it, to avail that subsidy, if you have not followed that, it's a reason for. It's justified for rejection.
My lord, for more than equitable, my lord, what one in equitable consideration, my lord. And so for subsidy is concerned, how to deal with the subsidy, my lord. In fact, my lord, whether my lord, for one, my lord, for 13.
Sir, for a moment, forget this.
My lord.
There is no decision of the Supreme Court.
My lord.
Since you are following, since you have applied this, claiming toward the subsidy under the scheme, which provides the do's and don'ts and how to avail the scheme, subsidy, if you have not followed, they can.
My lord, in fact,
is it not a good ground for, ground for rejection?
My lord, in fact, respectful submission is like this, my lord.
Yes.
My lord, so far as the other issues are concerned, my lord, if my lord, grossly, my lord, the petitioner is at default.
Yes.
And my lord, so far the scheme is not followed in total, or my deviation in many count or something, whatever it may be. But here is a case, my lord. Where is a case? There is a case only, my lord, for 1300 buses, my lord, which was accepted, my lord, out of 46,000. My lord, there is a mistake or delay or something, my lord.
Minor mistake and minor discrepancies has to be ignored to avail the.
So subsidy is concerned.
Subsidy is concerned. That is your submission.
Submission, and my lord, in fact, my lord, again, I am coming to the judgments also. Where judgments are concerned. In fact,
one judgment is enough.
No, in fact, how subsequently followed also. I am come to division bench judgments. I am not referring to single judge judgments. Division judgments also. I am
one more than enough. One more.
And my lord,
just one more. Not all those so many judgments.
My lord, in fact, my lord, so far MP Sugar Mill is concerned, my lord, Motila Padampad. In fact, my lord, it has to be, my lord, they cannot simply say that, my lord, for this small thing, or my lord, what the promises are there, they cannot, my lord.
Give me this. What's that?
My lord, this is division bench judgments of the Guwahati High Court, my lord. My lord, where, my lord, in fact,
the citation?
2024 NEJ, page 1.
Name of the party?
In fact, my lord, here, what happened? Even, my lord, for small issues, my lord, when, my lord, subsidy was not paid, even, my lord, delay was there, a small delay or something, whatever it may be, even on that ground, my lord, even interest was also given on equity restitution, even there is no provision of, because they cannot sheet over the subsidy, my lord, because what the court said, that it is benevolent public purpose to achieve. Because for a small thing, clerical thing, my lord, the whole thing cannot be. My Lordship may kindly come to para 19. I will also, my Lordship will not bother with too many, my lord, judgments. As your Lordship, para 19, page 9.
Yes.
May I read, my lord? As mentioned in earlier part of the judgment, central interest subsidy scheme was floated to give incentive package for stimulating development of industries in the northern region. It is not in dispute that considering such attraction schemes, the applicant made investments and become entitled to payment of subsidy. The scheme for payment of subsidy was applied to all. Once a person fell within parameters of the scheme, the respondents by virtue of the scheme were bound to release subsidy in favor of the investors. A time frame has been provided under the said scheme. State level committee cleared the claim of the applicant for release of subsidy. However, no good reason for years together and as noticed above, subsidy was not released. But whether the reason was good or not, that has to be, my lord, also seen. Whether for some good reason or a bad reason, my lord, whether there's some justified reason. Then Lordship paragraph 20, the respondents under the scheme had no discretion to either not release the subsidy. They, my lord, 5 years time they took. Even after the, my lord, the inspection also they took 3 years time to sitting over the matter.
So that was delay in releasing. But here is a case, our case is, the case, present case is rejection of your claim
But yes, something
that you are supposed to complete within certain specific time, but you have not completed that uprooting. That's the difference.
In fact, my lord, yes, my lord, I'm coming to that also. In fact,
Once you are established, I mean, right to get the subsidy, avail the subsidy, if it is there, if there is any delay in releasing it, I think if I'm not mistaken, this is the case.
In fact, what happened? What happened from there, my lord? In fact, what happened here? 2019 inspection was carried on.
Yes.
2016 my lord, clearance was given.
Yes.
15. Thereafter, my lord, they are sitting over the matter. My lord, time and again they are sitting over the matter.
Rejection was on 2021.
Yes, my lord. Thereafter also, my lord, 4 years gone by. Then, my lord, we said that there be inspection. Then, my lord, they are silent over it.
Okay.
Now, my lord, what they say, my lord, my lord, rejection is, my lord, their emphasis was not on that. Emphasis on that, my lord, they without financial risks. They said without financial, that is the, my lord, the contention they raised in the affidavit, that without financial risks, my lord, that the NOC was granted. So, my lord, we have no right to claim. That is the affidavit. Contention of the affidavit is that since in the NOC it was stipulated that without financial risks, that was continued. It was incorporated. That's why the petitioner has no right to claim subsidy. Because they are not bound to give subsidy because they have not committed. This is the sole contention in the affidavit. Of course, in the letter dated, they said the condition because it was not within time. That's what, my lord, the contention was. But if I will read the affidavit also, their affidavit, because what the pleadings will kindly go by the pleadings. Pleadings says something different. They said that you are not entitled to because.
So, sir, you are not. You will not make a reply. You will not reply to the submission of the respondents.
Yeah, you will reply.
You will reply.
Yes, my lord.
So let them first.
We have replied and
you just can you just make your own submissions?
My lord, in fact, what happened? So far as the affidavit is concerned, they say because the judgment we are relying on rejecting our claim, because that was the case in Kolkata High Court judgment, my lord. That was the, my lord, in fact, the application was filed after the scheme was over. But here is that is not the case. So that was this first round of differences there.
Okay, sir. What I'm trying to suggest you is that you make your submission, your case, let them counter or argue, then you may make a reply.
Yes, ma'am.
If you are not going to give them a reply, then you may submit their affidavit now. This is what I'm just trying to suggest you.
But in fact, my lord, Lordship can see.
Yeah.
Whether on equity or on equity, my lord, manifest injustice has not been caused to the petitioner. That your Lordship can see because of the, my lord, one clerical mistake. Let it be a clerical mistake, my lord, is not there, as your Lordship pointed out. My lord, for that, my lord, whether, my lord, the entire, my lord, can be submitted. My lord, if anything is there, if anything is there, condition, my lord, has to be there in the scheme. That, my lord, even my lord, for little deviation, whether the entire.
I'm not saying in this case, but sir, as you know, better than us, better than me, equally, the equity cannot be applied contrary to the law.
No, my lord. Here, my lord, in fact.
Can it be?
Subsidy matter. Subsidy.
No. Can the equity be applied contrary to the law?
No, but here what happened? So far, law is concerned, but what happened? That's what the judgment was. But what the judgment says, my lord? Judgment says that, my lord, there's a case, my lord, in the Ghaziabad case also, Supreme Court said when there is no clause in the contract that provision of giving interest. Interest takes no provision but on equitable consideration, going by the facts of the case. Interest can be.
The contract is not a law as such. What I'm saying, can the equity be applied?
Yes, yes.
Can we apply the equity contrary to the law? Not of course. Of course not.
With the Supreme Court judgment.
Or perhaps not.
My lord, Supreme Court judgment said, my lord, Supreme Court judgment, Markham text also, my lord, they are also, my lord, I have not read.
Supreme Court said that the equity can be applied contrary to the law.
No, so subsidy. So, contrary to law, my lord, my lord, so far contrary to law, equity will not apply.
Yes.
That's why, my lord, contrary to law, my lord, even, my lord, even after, that's why, my lord, MP Sugar Mills case, my lord. It was subsequently in a Godfrey's case, my lord, Phillips case, my lord, said that yes, Supreme Court, even, my lord, that the promigi stable was there, but even subsequently in the larger public interest can be changed.
Okay, sir.
So we don't. Now,
Any other case law?
My lordship will kindly see, my lord, here in this case.
I think this will be suffice.
But my lord, if you lordship, my lord, then my
what more relevant you would like?
My lord,
what more relevant you would like to rely?
My lord, if you lordship, my lord, try to hold that I don't have a case. That in that case.
No, I'm not saying so. I'm hearing you.
So no. If you lordship, my lord.
And in fact, I have heard you.
No, my lord, if you
have, and almost you have completed your argument.
No, arguments over, but so for citing judgments, my lord. If you lordship,
please.
Or if you lordship wants to hold that, my lord, I don't have a case.
No, I'm not saying so. As of now. Until the time we finish the dictation and sign the order, I cannot say now.
No,
I'm just hearing. I've not heard the other side also.
Yes, in the interest of my prisoner, my lord, in that case, I would like to cite some or more
judgment. Why, sir?
More judgment on the issue where, my lord, where on.
I think if I'm correctly understood, this is more than enough. And this is also not required.
6-7 judgment. 6-7 judgments continuously it has been followed. This has been followed. Even
if it is followed, it's okay. Last one, which one is the last one? Followed by
this is division by judgment, even single judgment. How
division bench is okay.
But in fact, my lord, for small deviation from the scheme. There's a deviation of the scheme. The scheme wanted that within 1 month claim is to be made. The scheme claim was made after 2 months. The scheme said. Even then, my lord, by following the judgment, Markham textures, my lord, I could held that yes, even after delay of 1 month also. The scheme, because of the pragmatic manner, my lord, this look is to be entertained and is to be entertained.
Which one?
Subsidy is to be then in that case, number of judgments I have not brought
today. Just give one which is relevant.
In fact, my lord, if you lordship permit me, my lord. In that case, my lord, in fact, my lord, then in that case, my lord, I will cite all the judgments, my lord, one by one, my lord, where, my lord, what were the defects from the scheme, what were delay from the scheme, and how it was considered, how it was accepted. Get my lord, one by one, my lord, I will submit.
That will be sir, to be frank, simple knowledge, simple mind, very limited mind.
No, my
Discord. So I go by a simple way of interpretation and a simple way of dealing with the matter. Ultimately, justice has to be there.
My lord, in fact, my lord, in fact, my lord, in fact, my lord, we are learners.
So I believe this court, of course, too young to, too early to say. I am also still grappling. The law is so vast. By your support and your, only we learn. Let us learn together. But I believe in where there is no complication in the law. I believe in a simple way of delivering justice.
In fact, my lord, if you lordship, my lord,
I understand.
2 minutes,
I understand the senior lawyers.
My lord, 2-3 minutes, my lordship. First, the J. Taring judgment, my 2010. Then the Union.
That has been relied. It's all relied in this Barcon's case.
Yes, my lord.
So see that. That's why I'm saying.
Even scheme, my lord, scheme.
Why all the judgment has to be placed? The relevant. These 2-3 judgments which you have cited, this has been relied in.
No, but facts were.
relied and considered.
Facts was not narrated. Facts has not been narrated.
You give me the facts which is relevant, most relevant ones, sir. I request all the senior lawyers as well as the lawyers. Let us be, to the point and.
Obvious, my lord. I'm obvious, my lord. But facts, my lord, what the facts was, and how, my lord, the facts.
Let us evolve, change the thing. Otherwise, see, the principal sit like, Guwahati offers comparatively, it's a very small pendency other than the other big high courts. But then for Northeast, it's a huge pendency is there. So when it's not relevant, I don't believe in hearing the irrelevant thing. There are so many law. We'll apply and hear it in the appropriate cases.
True, but only Lordship,
I think
only 2 minutes I will take Lordship.
Huh.
What happened? Valuable time I've taken. I'm
no, it's not. It's for you all. It's for you all.
In fact, my lord, so far the appellate order is concerned, my lord, begin with judgment. There are the individual cases, the facts was not mentioned here. So those facts were in what circumstances, even after the scheme, when the scheme was not complied as such. In that case also, my lord,
How many judgments, sir?
The 3-4 judgments are there where, my lord, facts are the schemes are not followed. The scheme was within 1 month, the claim has to be lost to a delay of 3 months. Even then said yes, but still, my lord, with the Markham textual said no. So subsidy is concerned, you should be liberal. Then all that was accepted and said granted disbursed subsidy immediately. That was the J. Taring case. Then what was J. Taring? Barak Valley. Barak Valley, number of judgments are there where, my lord, they said that schemes were not followed. Even then they said no. So subsidy matter, you should not be so strict. So strict. But delay was there is a delay of 2 months even. Because claim has to be made within 1 month. They said no, you have not lost claim within 1 month. So you are out of the scene. So you know what is payable to you. There also. One matter. Here also, para 18, my lord, there is a delay, then also, my lord, the claim was allowed. Para 18 looks in my condition.
Citation, sir.
Citation, my lord, is for food products, versus Union of India, 2013-1 GLR 359. Para 18, my lord.
18. Yes, next.
May I read, my lord?
Not necessary.
So here also, my lord, is a similar, my lord, because in fact, luckily, my lord, I had one judgment in hand, my lord. Other judgments are, my lord, I have not brought because
it's okay, it's modern enough, I think.
In fact, my lord, if you look there with me, my lord, because those judgments will be, my lord, similarly, my lord, where, my lord, a scheme was not followed in toto. But when in that case,
where is the judgment?
My lord, J. Taring judgment and my lord, Barak Valley, my lord, I have not brought.
This has been considered here. In Marcon's case, it has been considered, relied and considered. I mean, considered and relied, I think.
But so for the issues, case is relied, but the issues, my lord, in what circumstances, my lord, Learned Single Judge was convinced. And
Pero alloys, Ghaziabad, Development, Official Liquor, Dayanan, J. Taryang.
J. Taring's facts, my lord, it will throw light how J. Taring is helpful. J. Taring, Barak Valley. Because the delay, my lord, for 13 the process, my lord, a delay of 1 month, my lord, whether the entire issue can be, my lord, entire claim can be negated. From Tuesday, I can submit. Let my learned friend, my lord, can make a submission. On Tuesday, my lord, we can submit.
That's all.
My lord, let my learned friend, after my lord, I shall be obliged, my lord, if lordship my lord, for Tuesday, my lord, grant me one day, my lord, so that I can place all the other judgments. I'll take lordship only 10-15 minutes, my lord. I can, where, my lord, the schemes, my lord, even not in corporate scheme, but subsidy, my lord, was granted. My lord, for a small, my lord, delay or something, my lord, the entire thing cannot, my lord, can be shut. That was, my lord.
Sir, for all the lawyers and seniors also, I just believe, as I said, we rely on, I mean, we look into the most relevant judgment. Cannot start from the 50s, 70s, 80s.
No, madam, in fact, madam, lordship is
So I find it very difficult. The moment you rely on the judgment, it takes us weeks time to go through those judgment, and ultimately we find that it's not relevant, and we started writing all these things. In the process, we take 14 days, then 1 month, so it gets delayed. Ultimately, the sufferer is the litigants. That's why our judgments are it gets delayed. Once we realize we'll have to go through it, and ultimately we find that it's not relevant. So that's why every day I request all the, I mean, lawyers, just place the relevant judgment, I mean, according to you. But suppose a judgment is decided, relied in in 2010 and relied in 2025, you just place the 25.
My lord, in fact, my lord, the lordship knows everything, my lord. In fact,
Now,
my lord,
what our, I mean, this thing is, practice is that we started relying from 2010 up to 2005, all those judgments.
my lord,
Then it took us, I mean, we cannot say they will not accept, but this is my personal request. This court request all the learned lawyers to place the just 2-3 judgment at best. That will cover the case.
my lord, in fact, my lord,
Unless, of course, there are really serious and the legal issues, a question of law, which needs to be deliberated. And at the same time, I don't believe in hearing, I mean, for hours, days, and months. Of course, subject to, as I said, constitutional or the legal issues, right? Exceptional cases are there.
my lord, in fact, my lord, lordship, my lord.
But as last 2 years of my tenure as this side, I hardly come across a matter where I can hear even for 2 hours. I mean, I'm unlucky, and hopefully I get to see that in the future. But in as usual, our practice, when I was that side also, our duty, that's our job. But ultimately, the justice delivery has to be evolved, and it has to be changed in a better way. That is what I believe. Of course, we cannot change overnight the system, but then at least we can try.
Well, in fact, my purpose was, my lord, that matter so the facts, exactly similar facts, my lord, where, my lord, the source facts are, my lord. That's what, but only, my lord,
you
only
just
two
place that,
direction, my
that's
lord,
all.
because that with the facts, or the facts are like that only. In that case, my lord, in fact, my lord, only facts I wanted to, and so far the bindings is concerned, but whether facts are what the fact is.
Yes.
And my lord, this was the facts, which is similar fact. What facts are, my lord, only the case. And every case, my lord, the facts were some are 1 year delay, some are 6 month delay, or 3 month delay.
It's not a,
This was, but even then, my lord said the subsidy matter, my lord, following the Marcon Express, yes. They said, no, you have to disburse. You cannot be.
that's why I said the judgments are not Euclid's theorem. It depends on facts to facts.
Yes, my lord. Fact, so for fact, my lord, that's why, my lord, what's up in, my lord, whether, my lord, they delay 1 month. My lord, for delay 1 month can start the entire.
Who is that J. Tharyang judgment?
My lord?
J. Tharyang judgment. Tharyang's judgment.
J. Tharyang, my lord, then, my lord, Barak Valley and where, my lord, there were delay in the.
Please, sir,
yes, my lord.
just place it, that's all.
Today, my lord, in fact, my lord, I'm sorry, my lord.
We're disposing matter today.
My lord,
Anyway, you give it afternoon. By afternoon, you give it to the. It's okay.
my lord.
Only more 2 judgment. Barak Valley and J. Tharyang.
Yes, ma'am.
Rest, even if they submit also, I'll not go through.
I'm not, the lordship knows everything, my lord. But only, my lord, my prayer is like this, my lord. So far the subsidy is concerned.
Please sum up your submission.
My only small submission is that were forced in view of the all the malady judgments and malord what the issues malord, whether but a subsidy for a small mistake or my delay can entire malord subsidy can be shut. Door of the subsidy can be shut.
Yes.
If the substantially is not in order, substance is not in order, then yes, malord they have a case. If this slight malord tripling deviation or tripling issues, malord, the entire thing cannot be shut. As per the various judgments.
Yes.
So that is my case, my lord. In fact, my lord, and then my lord, let my friend also make his submission. Then, my lord, I will come to their affidavit also, my lord. How they said it, on what count they said that we are not entitled to.
Yes.
That also I will reply, my lord, I will give my reply. This is my lord, obliged to my lord for giving much time. I'm sorry,
No,
my lord,
it's okay.
much of your time.
No, it's your
Valuable
time.
my lord.
We are here for you only. In fact, for the litigants. You are for litigants only. Yes, please. Yes, sir.
Lordship, the petitioner here seeks subsidy under a particular scheme.
Hmm.
The scheme my senior has already read out. It's
Yes,
at
yes.
page 24.
Hmm.
I will just point out one basic thing
Yes.
which would differentiate the cases relied upon by him and this case
Hmm.
is that in the cases which he has relied upon,
Hmm.
those were industries which were set up
Hmm.
under the NEIPP scheme 2007,
Hmm.
wherein subsidies like capital subsidy, transport subsidy, etc. were given
Hmm.
for a period of 10 years. And of course, after 10 years, those were modified. This is not the case. This is not a garden or an industry set up under the 2007 scheme. So there lies the difference.
Okay.
Now here, your lordship will come to page 28 of the writ petition.
28.
Page 28.
Yes.
C11A, I'm taking to clause 3.
Hmm.
Uprooting will have to be completed by 31st of March of the
Yes.
financial year for which the application has been submitted. Replacement planting to be completed within 6 months from the issuance of NOC. Lordship will mark these words.
Yes, yes. Just wait. I failed to, it came to my mind,
Yes.
where is that clause?
Yes.
I failed to ask him. I forgot to ask him.
My lord.
Anyway,
Now,
yes.
now your lordship will come to page 54.
Replacement of planting to be completed within 6
within
months
6
from
months.
the issuance of NOC.
Now, he files an application which is at page 54. Dated 12/12/2015, received on 30/12/2015.
So we'll take it the 3012.
Yes, 30/12,
Yes.
where he says we submit application under the T-Board so-and-so scheme of our garden section 12 and 14 of in the prescribed form by the T-Board, necessary documents. So by submitting an application, lordship, it is not an assurance that you are getting a subsidy. You have simply filed an application.
Yes.
And thereafter, lordship, at page 55, it clearly states that it may also be stated that this is being issued with the objective. It's not very clear in my
55.
page 55, the last paragraph. I'll just read out from my.
It may also be noted.
Yes. It is not very clear. I'm reading from my petition, my affidavit. There is no objection to your commencing, uprooting, and replanting activity at your own risk, subject to your fulfilling all the terms and conditions of the said scheme. Lordship, what was the term? That it has to be uprooted within 31st of March and replantation within 6 months of the NOC. And without any financial commitment on the part of the T-Board at this stage. Now, page 56, the rejection. Rejection was uprooting not completed within the financial year in which the application was submitted. That is 31/3/2016. In this connection, Lordship will again come to my affidavit at page 113, which your Lordship has taken note of. 113 in the middle,
Yes.
uprooting of T. Bush's dates. 15/2/2016, completion 1/3/2016. 2/3/2016, completion 13/4/2016. That is uprooted after the prescribed period. Now, what my learned friend is saying, that there has been a clerical error. Your Lordship will see, this is an inspection report of 18/3/2019. At the top of this report, your Lordship will find. And this is countersigned by the general manager of the tea estate.
Yes.
Have there been any error? This was done much later on. Should he not have brought forward the discrepancies, Lordship?
Yes.
Because it is he who has signed it.
Yes.
And thereafter, Lordship will see replanting of the uprooted areas. Replanting of the uprooted areas 18/4/2018 to 19/5/2018, 22/10/2018, and 15/12/2018. Now, my friend was making a suggestion that the inspection was done very late. Inspection was done on 18/3/2019, whereas he has completed his replanting only on 15/12/2018. So, the scheme prescribes that the replanting has to be done within 6 months of the issuance of the NOC.
Yes.
3 years, is it?
Yes.
Am I wrong? Oh,
36 months.
oh, I'm very sorry. I'm very sorry. I take back.
Within 3 years.
Now, what he is trying to bring in is, Lordship, some handwritten documents, which is annexed at page 50 as Annexure 5 and Annexure 6, to make a suggestion that this was a clerical error. Had this been a clerical error, why would the general manager of the garden countersign that? Now,
Yes.
so far as Lordship giving a liberal interpretation to subsidy schemes is concerned, Lordship will appreciate that the schemes, the money that is going out is public money. If this is made open, if we have to give a liberal interpretation, no, after maybe 2 months, 3 months also, we can give. It will open floodgates, Lordship.
Yes.
That is my humble submission. And so far as Lordship, the citations given by my senior Lordship, those would be under the industrial development scheme, where subsidy was given on capital subsidy, transport subsidy, etc., which would not per se cover the subsidy under the tea promotion scheme, Lordship. Because these two things are very different. That is my humble submission, Lordship. There was no assurance. We had given him a NOC, yes, you can go ahead, but you have to complete it on time. Then maybe he would have.
As per the requirements of the scheme,
Yes,
scheme
Lordship.
itself.
Yes, Lordship. Had he completed, maybe he would have had a good case, Lordship. But not now, after his general manager has signed that document, Lordship. That is my humble submission, Lordship.
So you are distinguishing the
judgments, Lordship, when Lordship will peruse, Lordship will see.
this Under Secretary Marcon's case. Marchand's Textiles is, what about this judgment?
So far as Daryang and those,
My lord, in fact, my lord,
Barak Valley and all,
Well,
those are schemes under the NEIPP 2007. Those relates to setting up of industries in
Industry
the
and nursing.
Yes, industries in the Northeast.
Therefore, this can be
That
distinguished.
can be distinct. Though it will not come under this scheme. This scheme will not be there.
my lord, so far as the my lord, time mentioned by my learned friend, my lord, that within 6 months, replanting should be there. Within 3 years.
I have taken back that. I have
Not
taken
six,
that.
6 months, not 3 years.
Where is 3 years? What does it say?
Page 29. Page 29.
See, this page 28 says the replacement planting to be completed within 6 months from the issue of NOC.
My lordship will kindly see.
How do we read it along with
My
it?
lordship will kindly see, and my lord, it has also their observation also in their inspection report also. Page 29 of our petition, para 11. Replanting in all cases shall be completed within 36 months from the date of completion of uprooting.
In all.
The completion of uprooting.
So how do you read along with this?
So my lord, if March means 2016.
Clause 3 you read. Uprooting will have to be completed by 31st March for which the application has been submitted. Replacement of planting to be completed within 6 months. Replanting and replacement is two things. Different thing.
In fact, my lord,
What is the requirement? See, this is replacement. What do this 114 says what? Replanting, okay.
replanting, my lord.
It's a replanting. So, clause 3, it's a 6 months requirement is replacing. Replanting is 3 years.
3 years, my lord.
As per clause 12.
3 years. And there is
So after
inspection report also says same thing.
Made the inspection.
Replanting only, no?
That inspection report also says that replanting was in time.
After replanting, we have made the
The
inspection.
inspection report also says same thing, that replanting is in time.
Replanting is
In time. In time.
replanting work in area has been carried on in accordance with the condition laid in the scheme. The bush population will so and so. So there's no issue.
With replanting, no issue.
No issue.
No issue.
Except the uprooting.
Only uprooting, my lord, that also, my lord, and in fact, my lord,
They said the Supreme Court, in the context of setting up of industrial only, they said that the pragmatic approach has to be
my lord, in
taken,
fact, my lord, in
not
fact,
hyper technical, but not in the T subsidy in T.
my lord, that is also subsidy. This is subsidy. This is also industry, my lord, tea industry, my lord, and my lord, so for tea industry, my lord, lordship, my lord, I will also come to that. And my lord, as you lordship suggested, my lord, I will not bother your lordship with other judgments.
I think
Only one judgment, my lord, which I have, my lord, given. That is enough, my lord. That judgment I will.
what is the what judgment?
This one, my lord. Just now, my lord, I placed before lordship, my lord. 2013. 1 GLR, para 18.
No.
That I am referring that one.
GLR, it's your food. 1 GLR.
Yes, my lord.
So I've noted it.
Yes, my lord. That, my lord, others, I will not bother you, lordship, my lord. Exactly, my lord. That's in the same line. There are also delay of 1 month, 2 months. So, as your lordship suggested,
In Iswar.
I will rely this one only.
This one is also for the industrial.
Industry must offer the tea also industry must what it's a scheme floated.
Scheme is scheme. According to
Scheme must offer scheme is when scheme is there. Now the question is, my lord, where the question is that whether the scheme slight deviation, whether the scheme can be negated. That is the purpose, my lord. The purpose is that how is to be scheme is to interpret it. How the policy is to interpret it. It is the policy of the government, central government.
Heard Mr. BP, Dr. Heard Mr. Dr. BP, senior counsel assisted by 8th OD, right? For the petitioner. And also heard Mr.
I'm RKD Chaudhary.
RKD Chaudhary.
For the respondents.
Deputy.
Yes, Lordship.
Deputy SGA for the respondents. I'll pass the order.
Okay, madam. My lord, if your lordship permits me, can I prepare a note and my lord, a small note, can submit my lord.
It's up to you. If you think that I may miss your submission, you may.
No, no, I'm not on that, my lord. So far, my lord,
Submit by evening, afternoon.
afternoon, my lord, not.
Then tomorrow, you just submit here. In that case, CAB, we'll make it CAB. Then in that case, hearing concluded, judgment reserved. Huh?
By Tuesday, my lord, can we?
Huh?
By Tuesday, my lord.
You submit it tomorrow. Small note, whatever you have submitted, not the entire thing. One page,
My lord, my lord.
so that your submission is not missed out.
No, my lord, I'm.
Notice though, it's very
No,
simple.
my lord, but it's not that, my lord. I'm not.
But only he has created a problem for me to distinguish the Supreme Court judgment and also I'll have to work on it.
In fact, in that my burden is again, my lord, double the burden, my lord. In fact, my lord, then in that case, I have to again.
Day after tomorrow.
Day after,
You just submit here.
How
We'll
this
not, we're keeping it the CAB with judgment reserve. You submit by tomorrow, day after tomorrow.
But in fact, my lord, learned friend, when you distinguish Supreme Court judgment, then my lord, then again, my lord, I have to, my lord, give some other judgment. But the schemes, my lord, whether the how, my lord, again, how it is distinguished.
You leave it on me.
This cannot go on and
Yes.
on.
You just submit your whatever written synopsis, whatever, your submission, that's all. Don't give all those judgment. I'm just looking into three judgment only. Not more than this.
But scheme is a scheme, my lord. Whether
Okay, I've understood. Therefore, I said, sometimes there's an apprehension of the lawyers that this court may forget everything what they have submitted. So it's convenient for, it's convenient for us also. When the matter is CAB, to be frank, if we get the written argument and the submit, not voluminous, it creates again a problem. 1 or 2 page, short notes, your submissions. Then it's convenient for us also.
Your lordship appreciated the issues within very short time, my lord. Your lordship is
your matter is very small. What's there? Because of you only, your erudite and the forensic argument that creates, confusion to me. Otherwise, I take it the things very simple.
When they want,
and I'm a simple man.
When they want to shut the door, my lord, then we have no other option but to.
We'll say. By day after tomorrow.
Yes, my lord.
You just submit here.
Yes, much lord.
I won't submit anything, Lord.
You just get the chair. You know.
No, I won't.
No, it's okay. I'll note it down. You just borrow. The book, the Xerox of this or the or my investment. Yes, or Xerox of the not the book. Yes.
This matter may only be fixed for admission hearing.
Yes. Why this has been listed for orders?
Actually, in the last occasion, both of us prayed for fixing a date of hearing
Ajay.
before Honorable Justice Borua.
It has been admitted.
In fact, a rule has been issued, my lord, in this matter.
So,
Way
okay.
back on 14/10/23.
Heard, Mr.
Rule
Rule issued. Then
Heard Mr. A. Dasgupta, learned senior counsel assisted by so and so for respondent number for petitioner and Mr.
then
But
probably if the rule has been issued, then it should be fixed for hearing.
Chakraborty and counsel for the respond all the respondents
only one respondent.
for only one.
Respondent.
Okay, this is against the thing.
An award passed by
Award
the
passed by the Labour Court.
Labour
Okay.
Court Guwahati.
Okay. As agreed to by learned counsel for the parties, this matter after when?
After Puja vacation.
After 4 weeks in admission column. For admission. For admission. Huh? For admission.
For admission to the.
For admission.
My lord, rule has already been issued, so it should go for hearing only.
So you said for admission.
Lordship will have a look at the order passed
Yeah,
on
my-
14/10.
okay.
14/10, it clearly says issue rule
For hearing. Huh?
for hearing.
Yes.
Can we have a date, my lord?
After 4 weeks. Puja vacation, they say.
And one thing, my lord, though I have filed my wakalatnama, my name is not reflected in the file.
Registry to reflect the name of Mr. S. Chakraborty for respondent. You file your any complaint is required.
No affidavit will be required because it's against an award,
Yes.
the LCR will
Leave.
be sufficient.
Leave. Hmm. Hmm. Yes, sir. Yes.
So these are the legal submission, Lordship, I have submitted, and in support of this submissions, Lordship, I am placing certain judgments.
Okay.
First judgment, Lordship, I am taking
It's
2011.
okay. You just give that list of judgment and along with the copy. Where we all are familiar.
Lordship.
Because will be the judgment will be reserved, therefore
Yes.
it's of no point.
But Lordship, only one point, Lordship, I would like.
Yes,
to.
yes.
Other points, Lordship, paragraphs.
The most the most important point which you would like to bank on is
Yes.
just
No, so far as the illegal several judgments are there.
okay.
One judgment is there for illegal appointment, Lordship. That is 2011 3 SCC 436.
2011
3 SCC 436. Here, Lordship, I am relying upon paragraph 35, 36, and 37.
36
35, 36, and 37.
The name of the party's name?
State of Odisha versus Mamta Mohanty, Lordship.
Mohanty.
Lordship, here I am basically stressing on the point, Lordship, those whose appointment are itself in violation of Article 14 and 16, Lordship.
Yes.
They cannot be granted the remedy of law, Lordship. That is the first point, Lordship, in this judgment, Lordship. That is one. And secondly, Lordship, any appointment without advertisement is an illegal appointment. That is, advertisement is the mandatory condition for recruitment, Lordship.
Yes.
In this 3 paragraph.
Yes.
Then, Lordship, another judgment I'm asking you.
On this latest judgment, 2024. Have you come across that?
24, I have not brought.
When the initial appointment is not in accordance with law.
Then it vitiates everything, Lord.
Yes, vitiates.
In this judgment also, Mamta Mohanty, that
No,
point.
that is been relied on. Latest.
Yes,
Do you have
latest
that?
judgment I am furnishing, Lord.
Yes.
24.
Lord, in 2024 judgment has been provided by us also.
Jago.
Jago.
Jago I have taken. So.
Jago on a different footing, Lordship.
Yes.
Their Lordship, it was appointment of Safaiwala's Lordship. They were part-time employees.
Other day I have taken.
And they were basically.
I think it's recorded already.
Yes.
I mean, I have noted down. Jago.
Yes.
2024.
It is not applicable.
Online.
My submission will be, Lordship, it is not applicable in case of contractual
It's
employees.
okay. Huh?
Second judgment, I'm relying upon, Lordship. It's 2008 8 SCC 92.
92.
Yes.
Para?
Lordship. Paragraph 17, Lordship.
17. Party. Name of the party.
Name of the party is, Lordship, State Bank of India and others versus SN Goel, Lordship.
Go ahead. Please.
That is true, Lordship. Lordship, here in this judgment, the Honorable Supreme Court has held, in case of contractual employment, Lordship,
Yes.
it is regulated by the contract only, Lordship, and it is not amenable to writ jurisdiction, Lordship.
Is it a contract employment?
Yes, Lordship.
Here.
Contractual, yes. In this case also, it was contractual employment, Lordship.
Present case.
Yeah, SN Goel, Lordship. Lordship, on this same point, Lordship, I am placing another judgment passed by the Delhi High Court, Lordship.
Why Delhi High Court?
It is clear, Lordship. It has been clearly
So
produced.
Supreme Court is not clear.
It is more clear, Lordship.
But Honorable Supreme Court judgment is clear. Why Delhi High Court? Anyway, just give
this is 2020 SCC Online.
2020
SCC Online, Delhi, DEL 3471. Delhi High Court. Party name is Sonalika.
3471.
3471.
71.
Sonalika Bhargava versus
Sonalika.
SONALIKA Bhargava, BHARGAVA versus Government of NCT of Delhi. That's a paragraph relying upon 44, 47, and 48.
Forty-seven,
47, 44, 47, and 48. Any book list there? Yeah. Next, Lordship. Lordship, that is a judgment basically on the point that court cannot direct for extension of the contract, Lordship. That is Sonalika Bhargava. Next judgment, Lordship, I am placing.
too many.
On different point, Lordship. On one point, I'm placing hardly two judgments, Lord.
Then
Next is 2018 3 SCC 218.
218.
Lordship. Here I am relying upon paragraph 5, 6, 7, and 8.
Yes.
And the point is, contractual employees has no right of renewal of the contract, Lordship. Get it renewed, Lordship.
Then
Then Lordship, another judgment is there, 2011 15 SCC 16. Contractual employee Lordship, judicial review.
Para?
Para Lordship, 8, 9, 10, 16, 20, 22, 26, and 28. Here the contract was terminated and not renewed, Lordship.
That's all.
Another judgment is there, Lordship, 2019 6 SCC 250.
6 SCC 250.
250.
Para?
Para 7, 8, 9, and 10, Lordship. Here, Lordship, Lordship, in some of the cases, Lordship, one of the objection raised was that no notice was issued before termination. Is that 2018 9 SCC. Lordship, last judgment I'm taking, Lordship, it is 2018 9 SCC 293. (2018) 9 SCC 293.
Para?
Para Lordship 36.
$36.
36, Lordship. Lordship, here the point I am trying to emphasize, Lordship. Paragraph 36.
Yes.
Lordship, although temporary ad hoc and contractual appointments are used in contradiction to a regular and permanent appointment, but between ad hoc appointment and contract appointment, distinction is there in service jurisprudence, and both the expressions cannot be interchangeably used. So I am referring to this judgment, Lordship, only to rebut the point that the proposition that one ad hoc employee cannot be replaced by another, that proposition do not apply in case of contractual employees. Lordship, kindly note that point.
That's all.
So that's all, Lordship.
Yes.
On the last occasion, your lordship asked us to formulate the bullet point. We have done a few bullet points, but I will just give a short reply also. Sir, where did we ask? Your Lordship may recall that they had taken an exception that we have given the employer the appointment orders of only plus 70. But if your Lordship looks into the point number 7, that clarifies the position. And we have filed this not only in the form of on the basis of the union, there are other people also. So sufficiently representative capacity is before your Lordship to agitate their rights.
The other writ petitions also the members of the within 771.
Yes, yes. Because as per this clause 7, anyone who serves more than 3 months will automatically become member of that. And we have given the constitution, and that is we have marked this as the annexure. Now your Lordship will kindly recall, we had placed one judgment of this Honorable Court, of the Honorable Supreme Court, that is 2024 SCC Online SC 3826. That is Jaggu versus Union of India. Especially if your Lordship looks at paragraph 22 and 25. The Supreme Court, Honorable, your Lordship has the judgment before your Lordship.
Yes.
Now, if your Lordship looks at first at paragraph number 22. The pervasive misuse of temporary employment contracts, as exemplified in this case, reflects a broader systematic issue that adversely affects workers' rights and job security. In the private sector, the rise of the gig economy has led to an increase in precarious employment arrangement, often characterized by lack of benefit, job security, and fair treatment. Such practices have been criticized for exploiting workers and undermining labor standards. Government institutions entrusted with upholding the principles of fairness and justice bear an even greater responsibility to avoid such exploiting employment practices. When public sector entities engage in misuse of temporary contract, it not only mirrors the detrimental trends observed in the gig economy, but also sets a concerning precedent that can erode public trust in government organizations. Now your Lordship will see paragraph number 25. It is a disconcerting reality that temporary employees, particularly in government institutions, often face multifaceted forms of exploitation. While the foundational purpose of temporary contracts may have been to address short-term or seasonal needs, they have increasingly become a mechanism to evade long-term obligations owed to employees. This practice manifests in several ways. Here also, these are clearly reflected in our cases also. These practices manifest in several ways. Misuse of temporary labels. Employees engaged for work that is essential, recurring, and integral to the functioning of an institution are often labeled as temporary or contractual, even when their roles mirror those of regular employees. Such misclassification deprives workers of the dignity, security, and benefits that regular employees are entitled to despite performing identical tasks. Arbitrary termination. Temporary employees are frequently dismissed without cause or notice, just like in our case. As seen in the present case, this practice undermines the principles of natural justice and subject workers to a state of constant insecurity regardless of the quality or duration of the service. Lack of career progression. Temporary employees often find themselves excluded from opportunities for skill development, promotion, or incremental pay raises. They remain stagnant in their roles, creating a systematic disparity between them and their regular counterparts, despite their contribution being equally significant. Using outsourcing as a sill, which has also been done in our case, Institutions increasingly resort to outsourcing roles performed by temporary employees, effectively replacing one set of exploited workers with another. This practice not only perpetuates exploitation but also demonstrates a deliberate effort to bypass the obligation to offer regular employment. Then denial of basic rights and benefits. Temporary employees are often denied fundamental benefits such as pension, provident fund, health insurance, and paid leave even when their tenure spans decades. This lack of social security subjects them and their families to undue hardship, especially in case of illness, retirement, or unforeseen circumstances. In our case, my lord, not only PF and all were deducted, but some were even given the regular pay scale. Now, your lordship will see paragraph number 26, which the Honorable Supreme Court was conscious after the judgment of Uma Devi's case, madam. While the judgment in Uma Devi sought to curtail the practice of backdoor entries and ensure appointments adhered to constitutional principle, it is regrettable that its principles are often misinterpreted or misapplied to deny legitimate claims of long-serving employees. This judgment aimed to distinguish between illegal and irregular appointments. Well, your lordship will kindly take note that whether our appointments can be termed as illegal or irregular. It is categorically held that employees in irregular appointments who are engaged in duly sanctioned posts and have served continuously for more than 10 years should be considered for regularization as a one-time measure. However, the laudable intent of the judgment is being subverted with an institution rely on its dicta to indiscriminately reject the claims of employees even in cases where the appointments are not illegal, but merely lack adherence to procedural formalities. Government departments often cite the judgment in Uma Devi to argue that no vested right of regularization exists for temporary employees, overlooking the judgment exclusive acknowledgement of cases where regularization is appropriate. This selective application distorts the judgment spirit and purpose, effectively weaponizing it against employees who have rendered indispensable services over decades. In the light of this consideration, in our opinion, it is imperative for government departments to lead by example in providing fair and stable employment. Engaging workers on a temporary basis for extended periods, especially when their roles are integral to the organization function, not only contravenes international labor standards, but also exposes the organization to legal challenges and undermine employee morale. By ensuring fair employment practices, government institutions can reduce the burden of unnecessary litigation, promote job security, and uphold the principles of justice and fairness that they are meant to embody. This approach aligns with international standards and sets a positive precedent for the private sector to follow, thereby contributing to the overall betterment of labor practice. In our cases, my lord, some of them have allowed to work for more than 10 years, 13 years. Suddenly, one morning, they wake up and say that these are all contractual employees. They have no right to continue. And by a same order, they have terminated all the 771 employees. And if your lordship will look, I have also placed the other judgment on the day one. One is that is Binod Kumar and others, that is 2024 9 SCC 327. Binod Kumar and others versus Union of India 2024 9 SCC 327.
It's not there.
I'll give it, my lord. Your lordship.
2000? 2024.
Yes, sir. Oh.
Yes.
I don't know. Your lordship will see here also the in paragraph number 7. First, your lordship will look at paragraph number 5. Having heard the arguments of both the sides, this court believes that the essence of employment and the rights thereof cannot be merely determined by the initial terms of appointment when the actual course of employment has evolved significantly over time. The continuous service of the appellants in the capacities of regular employees performing duties indistinguishable from those in permanent post and the selection through a process that mirrors that of regular recruitment constitute a substantive departure from temporary and scheme-specific nature of the initial engagement. Moreover, the appellant's promotions were conducted and wasn't, that is, of course, they were promoted also. That's why this has come. Then your lordship will see paragraph number 7. Seven and 8. Here also the court says that in the light of the reasons record, this court finds merit in the appellant's account that holds that their service condition as evolved over time warrant a reclassification from temporary to regular status. The failure to recognize the substantive nature of the roles and their continuous service akin to permanent employees runs contrary to the principles of equity, fairness, and the intent behind employment status. Then there is one more judgment your lordship has seen that some of the employees, they say that we have not been recruited by advertisement. But now when they replace this other sets of ad hoc employee, in this case also there is no advertisement, no notification from the employment exchange. This judgment also we have given it, your lordship may kindly look into it, that you cannot replace one set of ad hoc employees. This is a familiar law, but we have given it on the last occasion. So,
How many judgments?
Now your lordship will see in reply to their reply, your lordship will see the additional affidavit at page 313, the document.
It's already there.
People who are situated similarly like us, the corporation has regularized it. Your lordship will find that at page 313. I have given the type copy. The 316 is the original copy.
313.
313. Now you also will see 313 is the type copy, 316 is the original. Now you also will see the language. As per power of corporation conferred by the Road Transport Corporation Act 1950, vide section 19C, to provide for his employees suitable condition of service and in pursuance of the decision of the 177 meeting of the Board of Directors held on 22nd December 2022 regarding provision of financial and other service to the contractual workers of the corporation who were engaged on contractual basis from time to time and have rendered 10 years or above of continuous service with fixed and monthly remuneration. The management of the corporation is pleased to allow to draw a will. So this 29 people, we have given an example. This has been done by the AP Tiwari, managing director, is this corporation who has regularized their services, who are similarly situated to all these members of the union who have rendered more than 10 years of contractual service, if I take their term used by my learned friend.
Who is this AP Theory? Who has appointed them?
My lord, there are two persons, three individuals' name has cropped up. Your lordship has put up a very pertinent questions on the last day of the hearing. That what action you have taken against them? These people, they have now AP Tiwari has left Assam, gone on deputation after this case has been brought to this honorable court. The other person also, I think one has retired, but no action has been taken against those person. Nothing is on record to show that if our appointments are illegal, then how can these officers who have made these illegal appointments can go scot-free? Why not an FIR against them? Have you arrested these persons? Have you taken them for custodial interrogation? Nothing, man. So my respectful submission that this mass termination, which the ASCC has resorted, and they have, with one sweep, they have terminated all these contractual employees.
They have said they have not terminated. They have released you after completion of your contractual term.
Yes. Now your lordship will see 316. If you can regularize, on what basis you have done this 316, this 29 contractual employees, my lord?
I've taken note of that. Huh?
So my respectful submission is that these are the people whose services can be regularized, because if your term is, they cannot be termed as illegal. And whose money you may say that certain procedural flaw may be there at the initial stage, but due to our continuous service in the organization for all these years, we have now more like offering services as a regular employee.
Hmm.
And your lordship will see, even after this case, we had filed it in 2023.
Hmm.
Till today, they have not made any fresh recruitment. At least, my lord, till the time of this one is matter of when till the time when the fresh recruitment was there, we should have at least allowed to work. They had also that option. In the meantime, we could have looked for other. But
This is a corporation.
Yes, man.
Government corporation.
Yes, man. Even today also, man, they are running.
The appointment and selection are made by the corporation itself.
Yes,
Yes, they have
Not
their
by-
own service rule in terms
Not
of.
by the government.
Not by the government.
but it is.
What is the, I mean, what are the posts? Yeah.
But some are
posts.
conductors, some are computer operators, some are
21 posts, I remember.
Yes.
21 posts.
Yes, that list was there.
Where it was? Somewhere
in my affidavit also it is there, Lord.
21 posts, yes, yes.
21 categories of posts.
Okay.
Yes.
at page 76.
Yes.
In the release orders also, your lordship will find designations are there. It start from page.
When you were appointed, which year?
Well, since I represent the union, many of us have members have completed more than 10 years.
No, when you were?
Well, different dates are there, my lord.
Initially,
Yes.
from which year?
Lordship comes to the Revalidation law.
2013, 14.
It's
Prior
not
to
from
2015.
Just tell us.
And your lordship will find that list of the district wise at page 51
Hmm.
and page 52. From 51 to, my lord, your lordship will find the different categories. In WPC number 3422, the different categories. Some are mechanical helper, mechanical apprentice,
Page
office
27
assistant,
of the
security
Revalidation law.
assistant.
First appointment letter was of August 2013.
Ah,
Page 27.
page 27.
27.
So that's all, man.
Huh.
We are obliged. If my learned friends, they are representing other cases, because in one of the cases, there is an interim order.
That's why you are still all working.
No,
Because
only
of that,
4 people.
4 people are
Four
working.
people. All release panels.
Only when there is an interim order, only these petitioners are working.
Only in respect of 3 Lordship.
3
3 or 4.
3%.
Three-
In that case,
3 or
that is
4.
double 3.
Huh?
3%.
Lordship, that is 3314 2023.
3%.
Yes. Lordship, just one paragraph I would like to show, Lordship, in that petition itself. Lordship,
Yes.
3314 2023.
Item?
Item number to show. Okay.
Read petition?
8, Lordship.
Read petition?
Read petition 3314.
14. Yes.
Paragraph 14, Lordship.
What does it say? You just said.
They themselves considered that, yes, our appointments were illegal.
Who said?
The petitioner.
We never said it, my lord. I don't know about the others.
Your members.
He is also 771. Within
Yes.
771.
Within 7.
My lord, sure.
Para?
Para 14, Lordship.
14.
Page 30, Lord. Page 16, Lord.
My lord, your lordship will see the intent and the purport under which they were appointed.
Without following the recruitment rules as
Yes.
the petition.
The petitioners are not denying that the fact that along with them, number of candidates were engaged by some state transport corporation without following the recruitment rule.
That is in respect of others, but they want to say that they are themselves not admitted that they are illegal. They may say that they may say so many things, but your
No,
lordship
it's
will go
okay.
by that.
Otherwise, it's admitted that there is no recruitment rule was followed.
No, my lord, but advertisement was there.
No advertisement.
Yes, yes.
Some were called from the employment exchange. Even in that Mamta Mohanty's husband, it has been clearly.
Your lordship will find one such advertisement in 5379 of 2020. 2023 at page 23.
5379.
5379 of 2023. Item number 20.
Ah,
Page number 23 is one such advertisement.
ah.
23 is the vernacular and 22 is the type copy.
This is para.
At least one has preserved the advertisement.
Yeah, this is. 3314. 2023. Para 14. BC 5379. There is page
22 and 23.
for train driver.
Item number?
Page 16. Yes, some advertisement
Yeah,
was
we-
also issued for drivers and all 2012.
Item 20, sir.
Like
Item 20, sir.
And you have
Your lordship will also take one more point.
that one is that page one. This it's a regularization enhancement of the pay in your writ petition, which you have mentioned.
Yes, sir.
In your writ petition, you have shown some regulation order 313. What
Yes.
is it? It's a regulation or what?
But 313 is the regulation order of some of the members. 29.
This is for training, lordship, stipend.
Is
In
that-
Assamese, I am reading law. Lordship, it states, those who are taking training under the motor vehicle driving school, lordship, they are called for training.
by this page 22?
Page 23, lordship, the vernacular version I am reading, lordship.
Yes.
And they were for a stipend, lordship, of 3,600 per month. This is
Drivers
not
having
for regular,
valid
Initial
register
and
for one
not for regular appointment, lordship.
driving training for corporation. Yes.
Your lordship will also take note of page 95 in the writ petition number. In the association writ petition, page 95, paragraph number 13. It says, my lord, that as regard to the statement made in paragraph 12 of the writ petition, the deponent begs to deny the same as incorrect. As claimed by the writ petitioner, no decision has been taken by the board of ASTC to engage another set of ad hoc employees in place of the 77 numbers of employees already released. But your lordship has seen that they had gone for other forms of recruitment. It is pertinent to mention here that as and when there will be required, proper recruitment will be done by following all norms of public employment, where the 771 numbers of released employees shall also be eligible to participate.
It's okay.
Subject to
But just one page, lordship. Lordship, may kindly page 22.
It's okay. I've understood. What about this regulation, page 313?
The same officer, lordship. The main petition from there.
those are not terminated.
They're still working.
I'm not sure, lordship. So far as that particular page is concerned, lordship.
What is this?
Very concerned, main petition, please.
If there is no specific denial, my lord, then your lordship will draw the presumption in favor of those employees.
Go for fresh recruitment. and allow them also.
No, Lordship, that is not the issue.
Go for fresh recruitment, what I'm saying.
Fresh recruitments against regular posts.
Yes.
These are all contractual, Lordship. They were beyond the scope of, beyond the staffing pattern of ASTC.
Let them continue, my lord, till the fresh
No, no.
recruitment is there. Conductors, handyman is
We
always
have
required.
a specific staffing pattern.
Okay.
And all these 2,000 employments are contractual and beyond the.
No, 2,000 are not concerned. We're concerned 771.
Yes. Lordship,
You have released only 771
Yes,
out of
Lordship,
2,000.
we had total.
So how you fill up this post? Is it not a sanctioned post?
No.
There's no post.
So far as staffing pattern is concerned, we make a regular appointment. These were all appointed contractually. So out of these 2,000 Lordship, we found 771 illegal. That is why.
Illegal on what basis?
Illegal
because there's no post.
No, illegal on the basis of enquiry conducted by the.
No, it's okay. It's not the appointment procedure has not been followed.
Yes.
Well, only
It's
procedure.
not that there's no post.
Well, only.
Contractual, cannot be any post on contractual basis, Lordship. Lordship may kindly take the.
Well, only.
Are you not going to fill up this post?
No, we are not going to fill up this post anymore, Lordship. So
Why?
that is why we have taken a decision. So far as security personnel are concerned, these posts are not required, Lordship. These posts are not required.
Where you have stated? So us.
Lordship, if Lordship comes to my affidavit, in the petition, Lordship.
Well, in page 95, in paragraph 13, they have said that it is pertinent to mention herein that as and when there will be requirement, proper recruitment will be done by following all norms of public employment, wherein the 771 numbers of released employees shall also be eligible to participate subject to fulfillment of eligibility criteria to be laid down by the appropriate authority in such.
So there is a conscious decision was there that these persons are not required.
Well, only
No,
point
it's
by
not a
which they
question
can
of
stay.
requirement, whether there is a post of 771 or not.
No, these are not.
Show us from your
For that,
affidavit.
Lordship, I have to place the staffing pattern, Lordship.
Huh?
This is not in record, Lordship. We have a regular rule, Lordship, for
No, there is no indication that you are not going to fill up this post. What you are trying to say is, these people, what you have said is, these people have been illegally appointed, therefore they cannot be allowed to continue.
In our affidavit, we made one specific statement, Lordship. If these persons wants to participate
Forget
in
about
regular
that.
recruitment,
I am not on that I've seen. Are you saying that these, the post, there was no post
yes.
for this 771?
Yes,
There was no sanction, there's no regular post.
No.
You are not going to fill up.
At least these persons were not working against.
Forget about these persons, whether there was a 771 post or not, which can be filled up regularly.
These are not sanctioned posts, Lordship. So there is no question of filling this post now, Lordship.
So you are not going to fill up?
At least this post, no.
771
No,
posts?
no, we are not going.
But you have not indicated.
Lordship, in my affidavit, Lordship, one indication was there.
There is no post.
No,
Well,
these are
I'm
not
quite
sanctioned.
surprised by
Not
the,
sanctioned.
there were 2,000 posts for contractual employees. Where are those
2,000
others?
contractual employees were.
No, what we have seen is, out of this total 1,000 or 2,000 something, 771
Has only been
persons
targeted.
had to be released or terminated because their appointment was not proper, I mean, in accordance with the provisions
Yes, Lordship.
of law or accordance with the rules.
My lord,
You have not said that these are the, there's no sanction, there's no post. And you have not said that they have been appointed.
No, from the very beginning, we are using the term contractual, Lordship. We never use that against.
Your using is not whether, in fact, whether there is a post or not.
My using or not using that regular post, Lordship, would not change the staffing pattern.
Yes.
Staffing pattern will remain the same.
That's why I'm asking whether these posts are available or not.
Not available. These are not sanctioned.
Why you have indicated?
What I'm repeatedly saying, these are not sanctioned vacant posts. These are not sanctioned posts.
You are not going to fill up.
These, at least these 700, there is no scope at this moment.
Forget about 700. These posts, now they are no longer there. Are you going to fill up this post?
No.
Are you sure?
Yes.
Take instruction. Be
Lots of
sure. We'll be
instruction.
recording it.
On instruction.
When there is no post, how can we may suppose, in case, if we find that they are not entitled to continue,
Yeah.
we'll have to direct you to fill up the post in accordance with the law.
Not if our, so far as.
Because what I have seen is as of now, so far,
Lordship.
you have not indicated clearly that there is no post for the 700 post available in the corporation. Rather, what you have said is because their appointment is illegal, therefore they have been released.
But they have not used the word illegal, my lord. They have not used the
whatever.
word. Well, your lordship will look at their minutes at page.
Illegal we have.
No. Your lordship will look into the minutes at page 178. Your lordship will kindly look at the minutes.
We'll take it about 2. We'll continue at 2. Kindly clarify this. You take it.
In that situation,
First, you just find out whether there exists a 771 post in the corporation from where they have been removed. Number 1. Number 2, are they going to fill up this post in case?
Lordship is meaning this 771 only.
So obviously.
In that situation, Lordship,
Or the total post.
I will have the written instruction. I will place it tomorrow itself.
Why tomorrow unnecessary?
Let me also remain in the safe side, Lordship. Let me have the exact instruction.
Because it's very important.
Understood.
Ultimately, today we're concluding the hearing. So in case tomorrow, I mean, we'll have to be clear whether there's a post, whether the post exists or not, how many posts are there.
Well, your lordship will direct them to just produce the staff pattern, that how many are regular and how many contractual employees are working even today.
Placing that instruction tomorrow.
Tomorrow then. Well, just fixing it for that only. No further argument. All right.
1397 out of 2000 is still remaining.
Heard so and so. All this there. Senior lawyer, assistant, best friend, all of them. Then judge. Hearing to continue tomorrow. List on so and so. 3rd. Only for the purpose of that information. You don't have to file in it. You get the written instruction. Will
Lordship, I will clarify 2 points only, whether these posts were vacant posts or not.
You just, since you are fixing the matter tomorrow, you just get how many posts are there in the corporation? How many have been filled up? Out of which how many have been filled up? All right. How many remains vacant? Whether this post they were holding is a regular post or not, or are you going to fill up this post or not?
Well, lordship may also
because you said it, you said that in the inquiry or something, if necessary, the employees has to be appointed.
Lordship, one paragraph is there in my affidavit where we have stated that if this person wants to participate against regular recruitment, they are welcome.
That's right. That's why you have to be very clear. The total post, I mean, these 21 posts, different posts. Categories of post, total post, say stepping pattern. Your stepping pattern and whether this 700 post is a sanction post, are you going to fill up this in case?
Lordship,
if it is a sanction post, may also ask them to place on record, because this officers, the superior officers, what action they have taken. They have not come out on record what action they have taken against those officers who made those recruitment.
Yes, you may take that instruction also.
Whether any FIR has been filed and whether they have taken bail on those FIRs.
Appears that no action has been initiated.
That itself will not make their appointment legal.
It's all right. That is but people
we would like to
take
into
we are suffering today because we appeared before an interview board.
Am I clear?
Lordship.
What instruction this court wants?
Lordship, whether this 777 post, 71 post were regular.
No, first you show us, you ask for the entire stepping pattern.
Yeah.
How many posts have been regularly filled up? How many posts or remaining posts to be filled up, sanction or not sanction? Then you come to this 771 post.
Your lordship,
whether it's a sanction post or not.
Your lordship may indicate in your lordship's order here, then it will be more easier for you. Yes, man.
Then it's, after hearing the constituent parties come up, it requires certain instruction which would be provided by the learned Mr. P. Nayak, additional AG. the staffing pattern of the corporation, i.e., the total post of 20 and total 21 categories of post in the corporation. Out of which, out of how many posts have been regularly filled up, and the remaining vacancies. List of and council to also. No.
About the 771, then we have to
You
take so much time short because it comes from the division from different districts. The posts are not at headquarters.
Well, in the headquarters.
no, in that case, in that case, we'll say total number of 21 categories of post. All right. As to whether the 771 posts, which were appointed to the petitioners, are a regular post or not, and as to whether the corporation is contemplating to fill up the post if the posts are regular public section, regular or section. Right. Total post.
Understood correctly, asking me to obtain instructions.
Yes.
The status of the 771 post, whether we are going to make regular recruitment.
Yes.
Your issue will also direct them to provide the instruction to this honorable court whether any disciplinary or criminal proceeding has been initiated against this officers who are responsible for making this
It is also directed the additional agent to provide to obtain instruction as to whether any proceedings had been proceeding has been initiated against the three members of three officers, managing director one.
Yes.
Officers / managing director corporation, as sought to be, as indicated in the minutes of the meeting. You just take that information also.
This petition, the signatory of the his own daughter and son are also beneficiaries of this.
Okay, you have terminated us. These are small issues, my lord. We have.
His daughter are also beneficiaries of this.
I think, sir, better to. Are you over-aged?
They were also.
Are you over-aged now?
Yes, madam. Many of them will be over-aged.
Better, if it's a regular force, go for a regular appointment. Following the due process of law, you may be allowed to participate. If you are over-aged, I mean, they can condemn by applying the provisions of.
They are not sure only out of 2000, my lord, what has happened to this post of 771.
That's why we
let them come up with the instruction tomorrow.
Yes.
Then, if necessary, we'll again
tomorrow, Can they ensure?
No, you moment it comes, you can make a mention.
Make it two. Make it two. It's only for instruction, no further argument.
Yeah, bless.
Yes.
This matter pertains to an application proceeding under section 33C2 of the Industrial Dispute Act. Now, for the timing, let us go through the provision section 33C2. And
Other side is ready.
other,
Facts.
Ah.
Disputed facts. Is coming over the hour. So this is on the basis of a order passed by this honorable court. So our compensation will be if the order has probably decided. Order of this honorable court, you figure to the quantum.
Bro. Off karo.
They should quantify the amount of compensation they will be reserved. While you have filed before the labor code has passed the award, whether they have said there is no pending dues, as it has been held by this honorable in another written. The basis of the finding was done. So our compensation will be that has been already decided and held by this honorable. Labor code was justified in passing the award and saying there is no dues. However,
well, what happened in this case, 2 award was passed. So far, second award is concerned, is correct. Second award was settled outside the court.
It's not under challenge. Is it under challenge?
No. Two award is not under challenge.
Second award.
Second and first, both the award, both this award was in favor of the workman. The money due under this award was not paid. So we have filed an application under section 33C2. Under section 33C2 is nothing but an execution proceeding. The court has to compute the money, amount of money. Now, so far the first award is concerned, it was not settled. So far the second award is concerned, it has been settled.
Okay.
So my case before your lordship is that so far first award is concerned, as the first award has not been settled, so the proceeding should continue. Now what happened in this case, we have filed an application under section 33C2. 12 witnesses were examined. And out of these 12 witnesses, 11 were cross-examined. In the meantime, my lord, the proceeding which was initiated before the labor code was dropped. So we have to go slowly, otherwise we will be in trouble.
Corporation doesn't exist anymore. Even the union doesn't exist. The person who is challenging on the basis of being member of the union doesn't exist. Because the corporation doesn't exist, the union will not be recognized and exist. That's another point you address.
So let me address, or you can fix another date. Or let me address.
No, if the corporation doesn't exist any longer, so what would be the...
Well, corporation is the government of Assam company owned by the government of Assam.
So in that case, what will happen?
So it is represented by AIDC. So why he is appearing? He is appearing on behalf of the corporation.
No existence of only AIDC is only appearing on behalf of AIDC because the company was transferred to AIDC. However, it is closed as well. There is no assets, no liabilities, not non-assets. If it has to be before the labor code, there has to be someone representing particular. This is the original respondent.
Well, Lordship, can you fix a day another date? In the meantime, your Lordship may come to go through the papers. So shall I do this case here? If this subject matter is new to your Lordship, probably.
No, it's not a question of new. We'll learn from you only. We'll hear you.
Then let us
Chairman Task Force for PSU Reform Government.
Let us come to the provisions of...
You are for whom?
I am for individual.
No, this
is a piece for party game, and he is stating that party game is not in existence.
So in case if you are, if a direction has to be given, who has to pay this? If this
party game
doesn't...
No, the company has not been wound up. the establishment which product produces the goods, that establishment has been closed down. That is the basic difference below. No.
So come to the impugn that thing award which is under challenge.
No, let us come to the two award first. Then it will be clear. The first award is at page 22. Now, before that, Lord, let me explain the facts in nutshell. What happened? This is a company owned by the government of Assam. Now, it produced some fertilizers. This company was set up in the year 74.
Yes.
But it cannot be functioned properly. As the result, Lord, it was handed over one private party. But this private party wanted that some of these employees should opt voluntary retirement. And accordingly, 64 or 65 employees took voluntary retirement. And so far the other employees are concerned, they did not opt for voluntary retirement. Now, in the year 1999, the company could not pay any salary to its employee. For that purpose, they issued a notice that they will not pay the salary of the employees. Now, on that notice, the employees had raised an industrial dispute. Their contention is that the company is in existence, and if you want to close down an establishment, you have to obey certain procedure established under the Industrial Dispute Act. And accordingly, an award, a reference was made. Now, that reference, Your Lordship, will come to page 22.
That's where the order.
First award.
Where it is?
At page 22 of my writ application.
Where is the operative person?
Operative, yes. Operative portion is, Your Lordship will find. Page 31. Mallet. On careful scrutiny of the evidences and documents in record, though the management has not admitted about the closure of the industry concerned, virtually as the manufacturer is stopped, payment are not paid, the industry is practically like closure. Admittedly, no wages, salaries to the contestant members of the union are clear. The management is not justified for non-payment of their contesting employee as per the provisions of ID Act. Hence, the management is liable to pay, that is important, the amount payable to the legitimate employees who has not enjoyed under various scheme. The management is not justified for non-payment. Of course, the industry itself is a sick. On the one wages salaries due to the employees are to be cleared, and I do not like to allow the compensation in present fact and circumstances of the matter. The management is cleared. Management is to clear the wages and salaries from 1/1/99 and onwards. That was to the legitimate workers who are entitled to it. They prepare and award accordingly. They intimate the same from the government as per procedure. No, this award was not challenged. This was remained unassailed as on date. Now, your second award is first. Now, what happened? By the second award, they declared closure. Initially, they had not declared closure, but subsequently, they declared closure. Now, Your Lordship will find at page 32. Now,
where the closer
the Government of Assam Labour and Employment Department dispute by notification dated such and such referred an industrial dispute between the management of Harticam Limited and their union on the following issue: whether the closure, now it is a case of closure. Earlier, it was a case of non-payment of salary. This is the basic difference. And this award has been settled. And whether the closure of Harticam Limited with effect from 31/8/2003 afternoon, as intimated to some employees by the management is real and bona fide.
Yes.
Now, next, page 33. Whether the service termination of some employees with effect from 31/8/2003 afterwards by the management of Particam Limited are valid in the eye of law. If not, then what rights and benefits are entitled to the employees faced with the service of termination in other cases? Now, basically, the case is simple. The management declared closure of their establishment by a notification. Now, in order to close down,
Therefore, you are held to be entitled for compensation
Yes.
for provision.
yes,
Because it has been closed now.
yes,
Because the closure was not bona fide.
bona fide because the compensation was not paid.
So
Now-
you are entitled for compensation.
Now,
So
that
this has been settled.
this has been settled. Now,
Writ petition. Yes.
now this award, Your Lordship, come to the final conclusion at page 45. 44 starts. At the bottom portion.
In view of the statement in additional more for the
Page 44.
note to the effect the employees have daily received and accepted the closure compensation. The award passed by the arranged with the closure. Same will not revive as the employees have no further claim to make from the in the above background. This court is nothing remains to.
Now, this being the position, am I reading? At the bottom portion, this being the position, I am constrained to hold that the closure of the company was not bona fide.
It's okay, I've read it.
Achha.
Now the writ
This
petition
award was
filed.
challenged.
Huh?
This award was challenged.
So
Now,
the writ petition has been closed.
this award has been challenged and it was settled outside the court.
Okay.
And accordingly, the writ petition was closed down.
Yes, then
And closed. Now, my lord, we have filed an application under section 33C2 of the Industrial Dispute Act for their realization of both the award, first and second. Now, so far the second award is concerned.
it's finished. It's closed.
It's closed. But so far the first award is concerned.
Salary from 1999
99.
till closure.
Before closure.
Yes, where is your applicant? That application is?
My application. Yes, I have an application. My application, Your Lordship, will find the first annexure.
Page
11. That is the applications. An application under subsection 2 of section 33C of the Industrial Dispute Act. Now, let us start from paragraph 3. The employed workmen have not received their entitled wage and salaries and other dues of service for a period of more than 11 years since 1/1/1996 and some arrear pay prior to 1/1/96. The workmen have the right to receive the same. The workman applicant is duly authorized to act. The workman applicant is duly authorized to act and do the needful on behalf of the members of the Shramik Kalyan Manch by regulation and joint declaration and authorization, both dated 28/1/2007, and accordingly the applicant workmen have shown an affidavit on 9/4/2007 before the Honorable Notary, Kamrup, Guwahati. The said affidavit is that the persuasion of the aforesaid regulation dated 28/1/2007, sound affidavit dated 9/4/2007, the applicant workman has hereby filed this application before your Honorable Court. Please.
So what happened thereafter?
Yeah.
what happened thereafter?
Thereafter, we have examined 12 witnesses. And 11 witnesses were cross-examined. Now, because the second award was settled outside the court, the entire proceeding has been closed down based on that basis.
Whether when you settle the matter, it was not settled along with about the salary, wages and salaries. It was not the part.
No. So far the award is concerned, second award is concerned, that was
No,
settled.
second, I've understood when you settle the matter outside the court with the management, why was not this
No.
this includes the salary and wages?
No. According to them, the salary.
What is that settlement?
No, there is no such settlement, Lord. This.
47. Yes.
Now,
the writ petition has been filed to bring on record the fact all employees, if they have accepted the closure compensation, have declared that they have no further claims for the petitioner. Being when all the remaining 33 employees who are members of the respondent to have accepted the closure compensation as full and final settlement, their dues.
That was their statement.
All the including.
That was their statement before the court, and based on their statement, they have withdrawn this application. According to them, this was settled. No, we need not challenge because this case we are not claiming.
They have voluntarily received their ties with the petitioner have been on closure of the when they said employer for
Come page 47. At the time of admission of this petition, these court, while the ruling,
therefore the impugn order
reference number 14 of 2004 was challenged and it was settled.
Yes, then what is this impugn order? Award? Impugn order? Order under challenges who is? 60.
Page 60.
You come to that.
No, let me finish. No problem. We shall not hide anything. Don't worry.
Close the chapter of payment to be given to employees as the employees already have accepted one clause and so therefore I feel that in view of the bodies.
With a pair to pass an order
Does not
because
have any
employer.
authority to decide the fact.
Yeah. Reference case number 14 objectives are passed on 3/31/8/2016. The award in favor of the workman. The petitioner applicant is the elected president of the Shramik Kalyan Manch, a registered trade union, and opposite party is a company incorporated under the Companies Act 1956. The petitioner and the employer, they are entitled wages, salaries since 1/1/1996, and also they are entitled to arrear prior to 1/1/96. It is also found in the petition that the petitioner, he is an authority for filing of the petition. It is derived from the members to file the application by Annexure A, the resolution of the committee. It is also found that the petitioner filed the application accordingly, Annexure B, before this court for claiming the dues to them by the management since 1/1/1996. At the same time, the management side also, they have filed a written statement in the shape of a written objection against the petitioner. The petitioner President Workman has claimed dues as per, this is very much clear, as per case number 4/2004, as well as on the basis of the reference 2020. So far 14/2004 it was settled. Reference case number 2/2000 under section 3(2). This case also arises on the reference mentioned above the closure of the management of Particam Limited, all on a sudden, abruptly, which was not actual closure of law. From the reference case number 2000, it was between the management of Particam Limited versus the General Secretary Shramik Kalyan Manch, the government of Assam, referred this case for adjudication by notification dated such and such. The following matters were referred for the adjudication. Now, whether the management, so far the second reference is concerned, whether
For
the
educational matter, I have framed issue whether any money is due to the petitioner as claimed for. That was the only issue.
yes. So my case is that as 11 witnesses were already cross-examined, only one witness remained, had not been cross-examined. At that juncture, this petition was closed. So let them examine. And if the court, after examination, if the court is of the view, yes, you are not entitled to anything.
See, the problem is you have settled maybe in the proceedings, the challenge of reference 14, maybe. But once you have settled all the issues.
No. So far the reference 14 is concerned, reference is a closer company.
It's all right. That was on that closure was the held to be not bona fide, therefore compensation was directed to be paid. That was put to challenge. Now during that pendency,
no settlement was arrived at. It is
then
up to them.
No, they've relied on that. You are there, you are the respondent.
No,
in the writ petition, you are the respondent.
No, we are not the. In that case, it was.
You are not there.
You were not there.
You are not there.
So far, this case is concerned. These.
We're not the party. No. I mean, the petitioner here, we're not the party.
Let me check it up. I may be wrong. No, it was an expert order. Because of the statement made by them, let me check up. I may be wrong because the long demand number child reference, page 46. No, let me check it up. Yes, advocate for the non-appear. Yes, or she fine. Page 46.
What can we do when you had not appeared, when the matter was due?
It is on the basis of their statement this petition was closed down.
It's okay. But then you are a party to this Assam Industrial Development Corporation, government companies. Shramik Kalyan Manch. You are there.
Yeah.
It's your union.
But on that day we are not there.
If you are not there, what can we do? But
no,
your
no
party.
Problem. No problem. Let them produce the settlement. According to them, the matter was settled. Let them produce. Even now, if they can produce the settlement, all right, no problem. On the contrary, my lord, we have received the amount.
During the on oath, additional during the pendency, all the remaining 33 employees, you are part of that.
Why?
You are 33. You are the 33 employees herein now. Are you 33 employees herein?
Yes, yes.
Here also in this writ petition. Who are members of the respondent have accepted the closure compensation as full and final settlement of their dues.
It is their contention, my lord.
No, that has been agreed. When did you come to knowledge of this order?
The petition was withdrawn by them. We are satisfied with the closure compensation.
No, it's not been withdrawn. It says in the above, this court is obtained, nothing remains to be upon and the payment and dispose of with the results.
Yes, so far that settlement is concerned, that award is concerned, there is nothing. 2 awards were passed. First award was not challenged. Second award was challenged.
But then second award was challenged, but then you have settled.
No such settlement.
As full and final settlement.
No. Let them produce.
My instructions there, and if they have placed before the honorable court, that's how it resulted in the order, which is
so. Para 4 of the additional affidavit being relevant is quoted. It was made in the statement in
yes.
No, you produce the settlement. Can you not?
Let them produce.
Fundamental for
no, all that you first produce the settlement first.
Case 1. So come back to case 11, case 12. Says the petitioner is no problem. Preparation of the regulation that is solutions. For activity that is solution, the applicant work can be.
Where it is? Para? So that the opposite resolution to and so on affidavit that is the applicant workman is will file this determine the entitled amount due to the person 38 others.
Petition 38 others. Petitioner himself has taken a behavior of in case 69 severity.
No, you have not gone through the.
Petitioner himself has taken, he is claiming for himself also. The union which he represents, right? No edition returns not recognized. So let's point out page 9 of the affidavit that we have filed. WCDL page number 69.
No recognition union is required. If you please go through the provision of section 33C2, any person can authorize anybody.
Yes. Page?
Page 10, otherwise page 9, section 1 of the affidavit that the respondent has filed.
Affidavit officer, yes. Where it is?
Anybody, only individual capacity.
No, sir, that is there.
Salary including area salary so and so, earned leaves encasement, gratuity, bonus.
Yes, you produce this document.
That is part of the records.
No.
Page 9. That is the petitioner himself.
No, it is not our signature, Lord. That is there. Oh, why don't you produce this thing?
We have produced before the honorable court.
No, you can produce before this honorable court also.
Can you point to the record of that?
No, that information is there.
They have filed Bahalasnama, they appeared earlier before.
This petition is along with this petition. It is before your lordship. Papers of this petition is before your lordship, Lord.
Have you not received this settlement?
No. No such settlement was made.
No, what about this page 77?
Page?
77. Annexure 1 of the affidavit.
Page 77?
Internal page 9.
Page 9. There is not much signature in that. That is, they have filed it. Even they can produce it now.
Are you saying that they have not settled the matter?
Yes.
I'm
sure. That is, it will be more clear from the page 55 also. We have received the money on protest. No settlement was arrived at. Even if your lordship can check it up on the record. This statement was made, affidavit was filed. We have received some money, undoubtedly, but we received it on protest.
Where it is?
That is, that your lordship will find at page 55. There is a meeting word. The meeting note that ignoring the award which were passed in favor of the employees by the Honorable Industrial Tribunal Guwahati in reference case number 2/2000 and in reference case number 14/2004 and pendency of 251. This is the affidavit. This is the case which was pending before the Honorable Guwahati High Court and miscellaneous case number 251/2007. This is the application before your lordship. Before the Honorable Labour Court, Assam, Guwahati, the government executives have now issued instruction to the management of Messrs. Partichem Limited to step forward for technical closure of Partichem Limited instead of mandatory legal closure of Partichem Limited under the provision of the Industrial Dispute Act 1947. The government executive have also directed to collect receipt come. The government executive have also directed to collect a receipt come undertaking from the individual employees beforehand of making payment of employees' dues, which are fixed and calculated behind the employee's back. The matter of undertaking so obtained earlier under duress from the employees and already raised in another point of dispute in miscellaneous case number 4/2007 before the Honorable Labour Court Assam at Guwahati. In such circumstances, the meeting resolved that whatever amount on whatsoever term and condition is released to be received by the employees by the government through Ferticam management, the employees will accept the payment, but on protest. The regulation in now, if my learned can produce that there was a settlement, and if my learned can produce that all these documents were signed by them, then I have no case. So that can be decided only in the proceeding itself, which has been closed down after examining 11 witnesses. That is the only thing is the Labour Court is of the view, yes, that matter was settled. Then can be. So 11 witnesses were examined and cross-examined. One only remained, was not cross-examined. At this stage, it has been done.
What is that impugn order? Pending since this was of order is of 11/9/2013. 11/9/2013.
Yes.
What does it indicate that the evidence were taken? Witness were examined?
It would appear from the record. Case record is before your lordship.
Is there?
Page number to number. Ask it. Ask, there is there.
After editing every argument is also therefore the learned person the warning on the
Let me bring it out. लेबर को जो प्रोसीडिंग से बता देंगे कितने को लेबर को प्रोसीडिंग ऑर्डर ठीक है अच्छा ये कौन सा चीज लग गया आपको 36 शेड्यूल मिसलेनियस केस है 424 207 हां हां एग्जामिन करा से जी 11 में दिस एग्जामिन dispose of the case by pronouncing judgment. It is the last final relation. You will understand. Examine Croatia, examine India. Workman side of the dead party is present. You know, there is absent witness case. And if you have a position, settle. Let a boy work. I mean, examine Croatia. You can improve out of time. Fine, then. Coming question. Yes. So, 2008. 2008. You take that? Evidences are there in that.
How many witnesses?
11 witnesses.
Total 12 witnesses.
Out of 12 witnesses, 11 witnesses were cross-examined.
But then problem is, so, all right, during the proceedings, the court has observed that you have settled all the matter dues and everything. Full and final settlement was done. Therefore, it was closed. So once it is full and final settlement,
During the proceeding of the labor
what
court.
more proceedings you want?
Proceeding of the labor court.
Yes.
But that is being challenged before your lordship.
That's what I'm saying.
So
What's wrong in it?
No, it was not settled.
Settle. The impugn order has been passed saying that during the pendency of your application, when the proceeding was on before the labor court, court on their affidavit, court has recorded, the High Court has recorded that there was a full and final settlement.
On what basis?
Therefore, there is nothing to be remained.
Milord, on what basis this court has come to this conclusion? On what basis the court has come to this?
That is on the basis additional affidavit filed by them.
But they have to produce, they have to give evidence, Milord.
Not before the High Court. Not before the High Court. What evidence?
No.
Not before the High Court. No, not before. See, during the pendency of one of the connected the petition,
yes.
award reference case award against in reference case 14 was under challenge, right? During that pendency, when they said that
that reference
the workmen and the management has they have settled the matter as a full and final. So it includes any other.
With respect to that award, Milord.
Not only for that.
So far that
maybe that challenge was there, but when you have settled the matter on full and final, what remains there?
No, not.
And you have shown to have taken BRS also.
No. That is not the evidence on record, Milord. It is only on their statement the court has passed this order.
So what can we do? Once that has been passed, what's wrong in the labor court to say that they cannot decide? Because they said on the basis of the settlement, full and final settlement only, this has been closed.
No, but
this proceeding has been closed.
Where is that settlement? That is the crux of the problem. No settlement has been
Have
made.
you challenged that order?
Yes. And that is the
where is the challenge?
Before your lordship, I am challenging.
No, that's what I'm saying. The basis of the order is that writ petition, order of the writ petition.
Yes.
So have you challenged that?
No, so far the order of the writ petition is concerned, that is with regard to the reference number.
Therefore, in view of decision of Honorable High Court so and so, I have found that this court doesn't have authority to decide the fact. Again, also as Honorable Court has appointed, all payment has been cleared up the management.
Milord, so far
you want the wages.
One thing, Milord,
and it was shown that the full and final
Milord,
settlement has been done.
Milord, awards are different. One is 2000 and other is 2004.
I'm not confusing. I do think I'm confused.
One award has been set.
One is for first award, 2000 is for wages.
Yes.
Salaries and wages. Another is closer, where you have been paid a compensation, entitled to compensation. Yes. And the first award is 2000 is for wages and salaries before the closure. All right. Now
that closure compensation has been
put to challenge before the High Court in the writ petition. During the pendency, they have come up with an additional affidavit saying that the matter has been settled as a full and final settlement has been made. Yes. Therefore, that has been closed.
Matter has been
so once it is full and final settlement, it includes the wages and salaries. May not be subject matter of that.
Full and final settlement is with regard to the second award.
I have understood that is your submission, but then the labor code, what is said, when the closure, I mean, the disposal of the writ petition was on the basis of full and final settlement, which includes these wages and salaries, payment has been made
But
and you have accepted. Therefore, it goes. There's nothing remains. He had no authority.
no, we have not.
That is what the labor court has said. That's
Yes.
why I'm saying, what's wrong in that?
Because, oh yes, that I have understood. So labor court has said that there was a settlement.
Yes.
And according to that settlement, you have agreed to settle all these issues. That is the content.
Yes.
Condition. But
It
there
says
is
the closer
there
compensation is full and final settlement of their dues.
but we have examined 11 witnesses. Not a single witness has stated that the matter has been settled. And all these witnesses were examined.
See, these.
But these labor
Are you
court
saying
passed-
that? No,
labor court passed this award without.
Sir, you may be correct, but problem is this order of this High Court, where it has been taken a note that the petitioner who are members and respondents have accepted the closer compensation as full and final settlement
Yes.
of their dues.
Yes, closer
That's all.
compensation. Closer compensation.
Yes.
So for the
The
closer-
employees have been paid all their salaries, including the area salaries in the revised pay scale, which has been accepted and said without any demur. That's all.
No, Lord,
So you put to challenge this one, order of the High Court. It's not only the issue in the writ petition was closer compensation, right?
yes.
But then it has been noted, recorded that including the area salaries, revised pay scale, which has been accepted by the said employees without any demur. That has been recorded on this basis only writ petition was closed. I mean,
It was
disposed of.
recorded on the basis of their FTP and it was closed.
So you challenge this, unless you challenge that it's become
No,
final.
so far this award is concerned, we don't have any claim. High Court cannot go beyond the terms of the reference. The matter.
So you challenge this, sir. Unless you challenge, it has attained finality.
No. So far this award is concerned, so the High Court's order is concerned.
That is, okay, heard. I'll
No,
pass the order. Finish.
No, so let me go through the High Court's order and the
You
level.
go through page 26. I have read so many times. Please, sir. I have read it 3-4 times. Please, you have read it also.
No. Page 26.
Para 4.
Page.
Can you produce the
No,
settlement?
that is the main issue.
Just wait. We'll keep it part hard. Otherwise, if you cannot produce also on the basis of this, I'll dispose it of
Yes.
next week. Hard, Mr. A. Das Gupta. There's nothing like, no need to spend so much of
No need to
time.
spend. If they can produce any settlement, all that.
No, if they don't produce also, I'll decide. This court will, I've heard you. I think, you think that, sir, you think that I have not understood the
No,
case.
I don't think.
And
I
is it
think
a new subject for me?
No. I know your lordship since long back, my lord.
So that's why I'm trying. That's why I'm trying to impress on you that I have understood the case.
Your lordship has understood the case.
That's why I try to convey that because of this order of the High Court, the labor court was correct.
So your lordship keep it as part of. On the next day, let them produce our evidence, and if they not produce settlement, then I will make my argument again.
No, I will not hear again. There is nothing to be heard. You are saying that your case is that the proceeding was for a different award, which was not the subject matter of the writ petition, where the compensation, the closer compensation was the issue, subject matter. Your the matter pending, basically for execution in the labor court, is for salary and the wages, which is with regard to first award.
Yes.
Second award goes settled so far as the. But then what we have seen is the High Court has taken note of the additional affidavit filed by the management saying that all this, you have entered into a settlement, full and final settlement has been done, including the salaries and other wages with enhanced salary, you have been paid, you have accepted. So once you have accepted the salaries and wages, including the compensation, what is called? Closure compensation.
Closure compensation received.
That's what I'm saying. You try to understand. This is recorded, not only the closure compensation. Matters pertains to closure compensation, right? Which was pending before this court. Now they file an additional affidavit saying that everything is settled, full and final, including salaries and all that thing which you have accepted. So in that case, the labor code was correct in holding that in view of the order of the High Court, since the settlement has been arrived at with full and final.
Actually, High Court has.
Therefore, there's nothing to be, there has no authority to continue. What's wrong there?
May I read?
What you are trying to distinguish is, try to submit is that this writ petition pertains to closure compensation only. It was not about wages and all, which pertains to the first.
Yes.
Therefore, you could not have closed closed the matter. You could have continued, decide the matter, irrespective of whether High Court has, disposed of the matter.
Yes.
With regard to the. So what I'm saying to, by reading the order of the High Court, which has been recorded.
The operative portion of the High Court order.
The High Court has recorded.
47,
recorded that full and final settlement have been made, including the wages and salary which you have received.
High Court has only recorded their involvement made in the affidavit.
Did I say that court has held? I said court has recorded on that basis only.
Only. That is not the finding of the High Court. May I read that paragraph 5, page 47. Just 1 minute time.
No, I have read it. It's okay. Heard Mr. A. Dasgupta, learned senior counsel, assisted by Mr. So-and-so, learned counsel for the petitioner. And also heard Mr. Yes, no point out. Just please. Unnecessary we have wasted time for 1 hour. Sorry. Huh? Do you have the settlement? No, why not about that? Not only the settlement. I want to settlement. A settlement is there. And also heard Mr. So-and-so, learned counsel for the. Sorry, sir, we unnecessary wasted 1 hour. Yes. Any settlement is been annexed? Any resolution or a settlement? Record. You call for the records. The challenge is to the hour dated, the order dated passed by the. Where is this? Challenge made in this. Challenge made is to the judgment dated 11/09/2013 passed by the labor courts, right? The labor court Guwahati in miss case number 4 of 2027 under section 33 C, capital C, within bracket 2, bracket clause of Industrial Disputes Act, 1947, I think. 1947.
1947, yes.
Yes. Whereby the claim for wages and salaries in terms of the award dated. What is the date of award?
All right.
First
11/9/2013.
First award.
Oh, first award.
or dated so and so, huh? Passed in reference in reference case number 2 of 2000.
First
Or-
award date is 31/8/2006.
2006, huh?
11/11/2000.
In reference case number 2 of 2000 with regard to salaries and wages, huh,
11/11/2000.
of the workmen, huh? Next paragraph. The management has challenged the, where is that order of High Court order? Challenge the second award was dated so and so. What is second award? Second award of that with regard to dated so and so in reference case number 14 of 2004 with regard to pertains to closer compensation. Next paragraph. This court on this court taking note of the statements made in additional affidavit by the management that during the pendency of the writ petition, all the remaining 33 employees of the petitioner
Additional affidavit annex
Who
A
are-
series.
members of the respondent number 2 have accepted the closer compensation as full and final settlement of their dues, and the employees have been paid all their salaries, including area salaries, in the revised pay scale, which has been accepted, comma. Dispose of the writ petition, which was pertains to the claim of closer compensation. List of the thereafter the labor court in view of the order of this court in WPC number 251 of 2007 has disposed of the miscellaneous case being so and so, that miscellaneous case, present one, on the ground that the petitioner, on the ground that all the payment has been cleared up by the management as recorded in the above order of this court. This stuff. Next paragraph. Considering that the next one, having heard the learned counsel for the parties at length, and considering that the parties have entered into a settlement which appears to be full and final, includes within bracket includes all the dues, i.e. closer compensation and the salaries and wages, comma, the Mr. So and so, the learned counsel for the respondent number 1 is directed to produce the record with regard to the settlement, if any. Is it a settlement? the matter remains part heard.
Multiple.
This after a week. It's 2014 matter, we'll dispose it of.
Yes,
Next week, any date, hearing day.
that will be better.
Next date, if you want to submit on any other new point, sir, you may, but will not allow repeating of the
Yes, why
submission.
should we repeat? Why should we repeat, man? We have some other case also, right? These are pro bono application.
That's why we'll dismiss unnecessary.
No, that is why. But I will only raise one point.
We'll dismiss unnecessary. You have taken BRS.
No, that is Milord, all these things are not correct. That is why, Milord, we have accepted this report.
You
on
record
protest.
the settlement, BRS,
Yes.
everything. You just
Yeah, here is
Yes.
settlement, let them produce. Look,
okay.
in the evidence it is very much clear.
Sir, report of ভুল লিখে বলে দেন।
রিপোর্ট ঠিকই আছে।
হচ্ছে আপনি বুঝছেন না কেন এটা আপনাদের রেলেভেন্ট কেস হচ্ছে 251 অফ 2007 এটা 39 লিগে আছে এটা তো গন্ডগোল হচ্ছে কিছু খুঁজে পাচ্ছে
ও এটাই তো এই যে 39 তে ডিসপোজ
না আপনার কেসটা ছিল 251 অফ 2007
সেখানে ডিসপোজ হয়েছে 13
কেস নাম্বারটাই তো ভুল লিখেছে
ওটা
2007.
ডব্লিউপিসি টা
এই জন্যই তো 251 অফ
ঠিকই আছে আমি তোকে বলছি
Correct. So we'll say again, no? The writ petition be the writ petition 251 of 2007. 7.
yes
Why? It's already 2013. Yeah. Original, yes, see the original.
this is all
13, it's correct, not 7. Huh?
Because the order which was raised for the labor code, the declaration is of 2007, number is 251 of 2007, which is carried in the policy 62.
This is something different.
Yes.
This is different case. Okay, so you just said let the writ petition 251 of 2007 be tagged, disposed, huh? Within disposed, be tagged with, huh? Nine.
all
We'll finish it off.
that's all
Made, please, Your Lordship.
Yes.
Now, the petitioner before Your Lordship is the Assam Power Distribution Company Limited. What had happened is that back on 6th of March 2013, we had carried out an inspection in the factory premises of the respondent, my lord, and found that they were using the load which is above the connected load, but below the sanctioned load. On this, we had asked them to furnish documents. Umpteen times they did not respond. Assessment bill was raised. They raised objections. Eventually, final assessment bill was raised. They moved in appeal. Their appeal was allowed. We filed review. Review was not allowed. Dismissed. As against that, the petition is filed. Now, if on the point, Miller, because these would take into different rims and dimensions on the electrical part, they would depend on circuits and etc. How things were built up, whether the inspection report was correct or wrong. But in a nutshell, Miller.
Yes.
when electricity connection is taken,
Yes, yes, continue.
my lord, when electricity connection is taken, then there is a sanction load. Sanction load is the upper ceiling permit which the authorities would sanction for the particular connection. And there is a connected load. Connected load is the load which would be there on record as per the consumer as the authorities combine. It's sum total of the power of all the units or whatever is there in the premises, electrical apparatus. So it's basically an opening up that these are the things which is there. And based on the calculation, this would be the connected load. Now, the admitted position of facts are I would be only admitted, I'll come to the disputed load. The sanction load is 620 kilowatt. And the connected load is 425 kilowatt. When the inspection was carried out, it was found that the connected load was 607.80, let's put 608 kilowatts. Therefore, there was an increase in the connected load. Once an increase in the connected load was found, then the authorities issued a communication to them asking for specifically for documents. And that my lord finds at page 24, the initial part at page 21. 21 is the inspecting record or checking report, whatever we have done. I'll not take it long, I'll just pinpoint the part. Page 21.
Yes.
My lord I'll not trouble your lordship. 13, 14, and 15 point numbers. Point numbers 13 is the sanction load. Lordship is there. That's 620 kilowatt. Point number 14 is the connected load. That's 425 kilowatts. And point number 15 is the connected load found, which is 607.805 kilo, which would be on the higher side. Now, Manoj, at this point, I need to be absolutely fair. What was found connected load is within the sanction load, but above or higher the connected load originally. I'll not go to definition for the moment, but this is what the situation as arose. Thereafter,
what do you mean by sanction load?
my lordships. I will not take the definition later on. Sanction load is when an electricity connection is given to a unit or premise, there has to be a particular power which should be sanctioned by the authorities for the premise, house, unit, factory, etc. That is the sanction load. That is 620 kilowatts for the particular unit.
Yes.
Now, connected load original, it might be in the simplest form saying that whatever electrical unit.
You might have been sanctioned 500, maybe actually connected for less than.
Less, yes. Obviously, it has to be less only.
Yeah.
So the connected load.
So sanction is 620,
620.
and connected load original is 425.
Look, this connected.
And it is found connected
607.
607. Yes.
607. On the inspection, it was found that. So connected load would mean it's a disclosure rather by both parties that although sanctioned is X and all electrical apparatus unit, whatever you have connected, a sum total of the power would be 425. This is the connected load in original as disclosed and accepted by both parties.
So therefore, you cannot have more than the use more than that.
Have more than that, but there is a procedure to increase. Now, when it was found 607.
This is an inspection report. Checking report.
The same thing, the report is there.
Yes.
Then at page 24, my lord, action was not taken immediately. At page 24, the authorities had asked the respondent they kindly furnish the following documents, which are 1. Copies of the energy bill payment for the last 6 months,
Okay, you have said given this, huh?
My
Then
lordship,
has he replied?
this was not given, and therefore the assessment bill at page 31 was raised.
Hmm. It was not replied. These documents were not given.
My lordships.
Okay.
But at page 26, we had said we had approached the chairman, AACB, APDCL,
Respondent.
26 is approached.
Illegal inspection report from this person got the same benefit yes.
Now, on our assessment bill at page 31.
So the inspection was one-sided, unitary.
No, we had put them to notice, we had gone them.
Okay.
We carried out the inspection, that is their stand. Anyway.
Then where's the bill?
31. Which follows their objection at 36. I'm just not reading it because this is the
yes.
At 45, the authorities would come to a conclusion that yes, there was malpractice committed because you're using connected load higher than the original connected load.
Malpractice. Under section?
My lord, this is 5.A.4.1 of the AERC, that is Assam Electricity Regulatory Commission, my lord. We have this been produced. Now, this was there. As against that, they filed an appeal before the appellate authority at page 48.
Yes.
The appeal was allowed at page 71.
71 or 70. This is a type copy. Page 75 is what?
Page 75 is the appellate copy, appellate order.
Okay.
That was allowed. We filed a review, and the review was dismissed at page 89 order.
So appellate authority, what does it say?
Appellate authority, the order starts at page 75. It runs to page 85. Now, in substance, what the appellate authority has said is this. It had gone into a fact-finding exercise disputing the report of the inspection and pointed out that this is the way things ought to have been done. Some subtractions ought to have been done. This is the way you have wrongly.
What is the FIR? What FIR you have filed?
FIR we had filed as against that after that malpractice we had filed, but that was, they have also secured a bail order from this honorable court. So the matter, that part, authorities did not go to the FIR part. Now, so far as this orders, the appellate authority's order basically would turn into a fact.
FIR can be filed. I mean, it's on the basis of theft or power theft or malpractice.
I do not have on record the copy of the FIR.
FIR was on what is the allegation?
On this malpractice, a corresponding FIR was filed. I'll just point out from the pleadings, Miller. But actually, on the copy, I would not have at the moment.
Assessment bill in question be withdrawn immediately. 50% payment made by adjusted report monthly. Yes, yes. What is the review? Review order.
Review order at page 89.
89.
89.
Yes. 21/2014.
14.
Yes. What does it say?
That there was no ground for review.
Yes.
Then we come to the writ petition.
So, what is your ground?
Basically, it's between our stand and the authorities.
Yes.
Without elaborating absolutely, it is whether, although you are within the sanction load,
yes,
whether you had exceeded the connected load. Now, on this, at page 21, 22, Milo, page 22, the list of electrical, whatever materials or apparatus from where the calculation was made out is given. Their pleadings.
You point out what's wrong in the appellate order.
No, I'm not. The appellate order would go error in this point. Point to point, there is nothing on the part of the respondent authority, respondent to show that the calculation per se was wrong. If there was a factual error to the notice of the appellate authorities, it could have been addressed the order of remand on the point of inspection to the extent whether 425 was there or not, 607, what they had calculated. What the law says is that if at any point of time you even think of, desire of changing or adding onto the units or some articles or some things whereby the load may go up, the connected load, then you need to inform. And not doing that is a malpractice as per the law. I'll just pass on to my law, So far as the Assam Electricity Regulatory Commission, 5A 3.2, this is what
Before submission should be
I'm sorry, I presume I don't have. The B part, on malpractice.
Yes, it's okay.
Yes. Now, so far as the Electricity Supply Code and Related Matters Regulations is concerned, my lord, 5.3, if I may just read before passing on to my lord. Appellate authority has done a very technical calculation. My lord. Before I read the appellate authority's order, what I was pointing is malpractice as I passed on to my lord is there. On the B, the connected load being exceeded would be a malpractice. Point B. Lordship. And so far as the Electricity Supply Code Related Matters Regulation 2004 is concerned, it deals with the part district. May I just read the relevant part? Extension and alteration. Should the consumer.
Where it is?
No, this is here. This is on. I am. Would we pointed out what's a malpractice, that part. And this is 2007. 2004. There's a specific provision. I'll just pass on. If I just read out. Should the consumer, at any point, at any time, after the supply of energy has commenced, desire to increase the number or size of lights, fans, motors, etc. in his premises, or in any way alter the position of his wiring therein, notice thereof and need to change the connected load, if any, shall be sent in writing to the licensee. Now, if it goes up, there may be difficulty, there may be ways of regulations. So in substance, a harmonious reading of both would show that this is electricity. This is sheer serious things we are dealing with now. So whatever is the connected load, maybe you're within the sanctioned load. If you've gone a little bit higher on your own volition, you need to inform. So once we detect, we ask for documents. You do not do that. You go to appeal. And the appellate authority would do an exercise as if like the inspecting team and come down with it without.
Definitely, appellate authority can look into whether your inspection team, business team is proper or properly carried out or not. That can be looked into.
Team.
Otherwise, what's the use of having an appellate authority?
True. The inspection team
cannot be powerless.
No. Absolutely, we have the power. So far as the inspection team is concerned, so we are dealing with the time of 2013 now. So far as the inspection team is concerned, they carried out an inspection and gave a full chart of the electrical apparatus. They got it, and on what points they saw things had varied. That chart item wise was given. It's part of the record. That was not denied. Rather, to think whether there was coloring, painting done, it could have been saying what is the changeover. In the technical parts, there were some resistance by the authorities, by the respondent, which was taken up before the appellate authority. The question was, in substance, if there is the slightest of increase in the connected load, not change, increase in the connected load, without there being any wrong thinking of the part of the authorities, we often do, Miller, we often install a light or a fan extra at our place. In terms of the electricity thing, it would be a malpractice. We cannot go above the connected load. Sanction load is the ceiling. We cannot go beyond that. But so far as a connected load, because there's a protective layer. So this part lost sight. So therefore, effectively, when the dispute was, they say you need to minus something because of ABCDE. We say we got these things because of ABCDE.
So there is a final findings that this approved SLD clearly showed the total load of the industry was 3.756
The understanding
kilowatt.
My lordship.
And the authorized connected load is 425.
Correct.
Below that.
Because the appellate authority on its own proceeded to calculate and subtract a figure from 607 to come to a figure that is 423. The detailed report was there, how we calculated the entire thing. And they had denied, not item wise. They had denied us. Now, if I would point out this, the denial at page 26, how they take up the things, Miller, at page 26 of the petition, Miller. That is too technical. We say item wise, the things are there. We deny item wise, whether it's there or not there. They say other things were there. No, if it is there and there's a reflection in the load, it's wrong. Page 26, it's by them, Miller. May I read that? Paragraph 1 onwards.
Power having connected. Yes.
May I read?
Yes, yes.
That in our factory premises, there is a power supply having connected load of 425 kilowatt against sanctioned load of 620 kilowatt of the industrial category. And our factory has been running well within the sanctioned load as well as within the connected load till date. And prior to 6/3/13, there was no allegation of excess load consumption by our factory. At no point of time, although time to time, representatives of ACB, APDCL have visited our premises and till date of the consumption bills raised by authority have been paid in time by time. We say, Miller, page 24, point number 4. The questions we raised, we sought for documents. Last inspection report carried out by ACB technical team that was not given to us. On this, we had done earlier. Next, then all of a sudden claiming himself to be chief vigilance officer along with some subordinate staff and police force had visited our said factory premises in my absence and also in absence of an authorized manager of the factory and without proper verification of the details of connected loads started in the most whimsical and mechanical manner. Preparing inspection report and subsequently inspection report was prepared by them and forcibly obtained signature of one of our employee over the alleged inspection report by showing threat of police force. The state staff had duly recorded his objections regarding illegalities in the alleged inspection report while putting his hands thereon, which is very much apparent on the body of the said inspection report, that is 6/3/13. That on mere perusal of the inspection report, it transpires clearly that the connected load of existing motors have not been recorded on its actual capacity, and the same of the load have been recorded in the said inspection report. In the respect of the motors, machines kept as standby spare, and even for 2 motor machines, the connected load has been recorded separately in the most illegal manner, although there is connected changeover for not to run the same simultaneously, but to run any one of the 2 motor machines. In respect of 4 mixing mills, the load has been shown illegally as 62 kilowatt each, although in place of the said 4 mixing mills, only 3 mixing mill motors are available of having strength and capacity of 45 each. And in this way, 1 and 13 has been shown as excessive, which is illegal. Pausing for a moment, my lord. They do not deny the existence of what was found. That in respect of the changeover fitted in between motors of the mixing mill and a kneader machine, which has been shown separately, wherein the excess load has been recorded as 45 kilowatts against the actual load. in respect of one kneader and one mixing mill wherein changeover has been fitted or not to run the same simultaneously, but to run any one but the two motor machine, the difference has been shown as 45 kilowatts, which is absolutely illegal, not in conformity of the actual consumption. My lord, for the meter meeting machine, everything, there is no denial whatsoever. It is one thing to say the things are not there. It is quite another to say the way you calculate it is wrong. That in respect of the two extruder,
How you calculate it? It's just existence of the machineries and all. It should be based on the meter reading.
whatever things were there on inspection, the chart was made out as to each what is, suppose on the bulb and everything is written, what would be the consumption. We put it down, we jot
You
it down,
calculate that.
calculate it, reflect it.
No, it's not on the basis of the meter. The consumption, the energy consumption is not on the basis of the meter.
My lord, meters would be to first the bill, but units will have the connected load. Consumption would raise to a
So
bill.
you calculate on the basis of the units on the materials
There-
available on the premises.
There will be two parts. One, I may have lot of units, I mean, electrical units in my place.
Say we have
In the High Court we have. We may not use.
100 bulbs.
We may not use.
Huh.
This bulb may not be used. Therefore, it will give a different reading when the meter is.
Yes.
But if the bulb is there, it will be calculated towards the connected load. I am on that. Right? Regardless
So
of
the calculation on the basis of the units,
you have, apparatus you have.
whether it is used or not.
Regardless of that.
Regardless
That
of-
is the connected load. By the definition, I can show that. Connected load would means whatever things you have. So definition. I'll just read one line. Connected load means aggregate of the manufacturer's rated capacities of all energy consuming devices connected with the distribution licensee mains in the consumer's installation and which can be simultaneously used. This shall be expressed in kilowatt, kVA, HP units and shall be determined as per the procedure laid down the licensee with the approval of the commission. So it's sum total of whatever units whatever apparatus you are using.
Using or it's been placed?
Placed. I mean, using means placed in the premises.
Placed in the premise.
Exactly. This is the
Suppose you're supposed to use 30 kilowatt.
30.
Right?
30.
You have put in a unit or machinery
Right.
which may require 60.
Then the law is given.
So
Then the law is. It says.
so that will be counted as malpractice.
Yes. It says.
Unless it is actually used.
If you use, things may be different. It may go above the sanction, may not be
Yes.
sanction. But should the consumer at any time after the supply of energy has commenced desire, only thinking to increase the number or size of light, fans, motors, etc. in his premises or in any way alter the position of his wiring therein, notice thereof and need to change the connected load, if any, shall be sent in writing to the licensee. Things take different point because the connected load basically is what the understanding, these are things that you place. We are safe, everyone is safe. If you want to go above, please let us know. We'll inspect, get it done. So these are technical issues, we know what is being addressed. But the fact it is there is not denied. So everything has to be denied point-wise. And the learned appellate authority and the learned review authority went on a technical premise. Page 45, which was the first order in our favor, it says the vigilance team detected a load of 607 something connected to the mains. Page 45. It's very important. Those were there.
Yes. Where?
Page 45, second paragraph.
The vigilance team detected.
My lordships. The vigilance team detected load of 607 so and so connected to the mains, which was 182 point so and so more than authorized connected load of 425. There was no record of changeover switch and standby motors in the report of vigilance team, and as such, your claim in this respect cannot be entertained. As per statement of vigilance officer, considerable time was given to you to submit the related documents like layout, diagram, etc. However, you had failed to submit the same to the chief vigilance officer within the stipulated time. There's also infringement by way of removal of specification plates of machines and painting on top of the machineries which are prejudicial to the supply system of the APDCL. Taking into consideration above findings, I would like to convey you that malpractice so and so committed by you is proved, and as such, there is no scope for revision of this bill at this level, and the above bill of rupees 7 so and so is retained as final. However, you may prefer appeal, and so they did, and it was in their favor. What I am on is, if it goes above connected load, it may, but prior to that, even if you want to change the wiring, put on an extra light. If it goes above connected load, you put us to notice. We'll sort it out. What needs to be done. But if you so do, and at your peril, you cannot take a stand later on. No. Whatever it may be, I was within the sanction load. Denial must be specific, my lord. That what is found was not there. The authority was specific, the initial order. Changeover switches, everything were not there. So whatever found was there. And they put on paint. On top of the units, they put on paint so that we cannot assess and read also. Everything was put. They were given the chance to reply to us by the documents kindly placed to us. Nothing was done. Therefore, this was on the higher connected node, the malpractice was there.
So therefore, I just wanted to know, it's not only the actual consumption.
The consumption on the bill.
It's not on the actual consumption.
Bills would go higher. See, my lord, for the connected load less also, we can have a very higher bill, a moderate bill, and a low bill. How I use at my residence, if I use everything, it would go higher, if not. But the connected load cannot be more than what is the initial connected load.
So how you raise the bill?
On the consumption. Consumption and connected load are different things, my lord. Bill is...
So what you have charged?
What they used. What they used, we have charged that. We say it's a malpractice.
See, what is your, I just wanted to know, what is the bill about?
7 lakh something.
It's on basis of what? Is it on consumption?
The 31.
You are seeking, asking for the bill.
My lord.
On the basis of the consumption only.
33. We'll put it, my lord.
Yes.
This is the bill. On the right hand side, second column, connected load 425 kilowatt. Now on the inspection, detected load comes 607 so and so. Now assessment bill.
So on the basis of 607 only you are.
My lord.
You have
assessment bill. Chief Vigilance Officer dated 6/13. Excess load 607 minus 425 182. On this,
that's why I just wanted to know. Maybe there, as per the regulation, there may be this is the way to be done. But then, is it not little? Strange. The basis the calculation of bill on the basis of the consumption. You find a certain units is there.
Correct.
So your maximum or above the permitted connection load, on that you can raise the bill.
So far as on detection of excess load, they follow the formula.
This excess load is not on the basis of the consumption?
No, this is given below. If logic comes below.
Yes. Excess load,
very technical form. How they find out in a particular formula,
We're not expert, but then
we understand.
It looks,
everyone out here.
Yes.
I understand.
Yes.
So this is the way they calculate on the excess load.
No, my curiosity is
absolutely. I got the point, I thoroughly got
the simple term. If the bill has to be on the basis of the consumption.
Therefore, in the books of.
But I understand regulation and all it permits.
True.
To have this kind of calculation.
On the question of excess billing on the part of consumption is one way.
Yes.
And on the excess load, how they calculate out, this is given. But of course, we're not being.
See, it is basically to prevent the theft and the malpractices.
My logic.
This kind of penalty you have been. How to.
This part we can explain. This part.
Yes.
Technical part we can explain.
Yes.
That's not the point.
Continue, please.
The sum and substance is in respect of electricity. When there is a provision for you to put to notice and then act accordingly, do that. Whatever we found was put on record. We asked you for documents, nothing was forthcoming. And then the order of the authority was there. They said, no, changeover things were not there. But the appellate authority went on its own fact finding to come to an order and the review was dismissed.
According to you, he doesn't have that authority.
No.
He doesn't have the jurisdiction go into that area.
Appellate authority would certainly have an authority, jurisdiction to go into that. But when it's one-to-one on the things that no, these were kept separately, this is not there. Sitting at the office, appellate authority could not have an inspection there because it is not on evidence.
Purpose.
Well,
It's a purpose.
What I'm trying to say, is that certain things are factual to the extreme. That we say we found that, our authority says that yes, you have not been able to show that, and the appellate authority says no. This is the way it ought to have been done. It's not there. It's not connected. So these would little bit.
Then what it amounts to?
On
What
this,
does it amounts to? According to you?
Jurisdictional error, if I may put it that way. Not on the administrative side, but quasi-judicial on the jurisdictional error. I put it this way. Now, if there could have been two minds of the appellate authority, that yes, maybe the respondent is coming up with a version which was not properly explored. So on the unit of the quantum, there could have been a stay and the matter could have been remanded back because their stand is they have not increased. If it's 425 as on date, it ought to have been back then. Put all the things together. They do not deny the things were not there. They say the calculation was wrong.
So jurisdictional error.
To that extent where no one could have seen through.
Yes. Any deviation from the regulation and the act?
Yes, so far as they connect this on the aspect of malpractice, it just says if it exceeds the connected load. It does not say 1% or 100%. And on the, if I may pass on this,
use of unauthorized
load,
exceeding unauthorized connected load. Method of assessment and charge in case of TAP pending adjudication. What about the FIR?
That we do not have. My senior colleague might have a copy for that. 5.3.
Matter ends there.
Yes,
you have annexed that. You have stated.
5.3,
What is this?
This says.
Same thing.
No, it's not the same thing. 5.3 would be.
This is what?
When you want to have
a related matter. This 2004. This is
2007. This is both a different mirror.
This is what?
One is the AERC thing. I do not have an extra copy with me.
Regulation called the Assam Electricity Regulation Commission. Code 2004. This is what?
What I'm showing 5.3 is what is to be done when you want to increase. That part and no more.
No, what you have.
There's a notification,
No, what you have given is.
Two are different things,
Yes.
I'll have a copy done and hand it over.
These are notification.
Of the 2004, Lordship takes a 5.3.
This is Regulation 2004 First Amendment.
Yes, 5.3 Lordship takes up for that. 2004.
And this is
a notification.
No, this is what? Second one is
on the malpractice parts.
Assam Electricity Regulatory Commission, Electricity Supply Code and Related Matters Regulation.
5.3 is what is to be done when you want to go above board.
The same thing.
I'll show you.
Assam Electricity Regulatory Commission.
30th August 2004.
No, this notification 30th August 2004.
Yes.
Second one. This is of 2007.
What I'm showing is that from the 4 it's 6.3.
There's an amendment.
I'll show you.
Is it an amendment or what?
7 and 4. 7.
I'll just hand over. I'll have extra copies done and hand it over.
Same regulation.
I'll show you.
2004. But then different notification with of 2004 and 2000.
I was on the authorities' way of exercising the jurisdiction.
No, I just wanted to know what is the.
Yes. The notification 8 May 2007. It is Electricity Supply Code Related Matters Regulation 2004.
Same thing. The other one is also.
Yes. This on which we are 5.8.3.2 exceeding connected load. This was the factor of exceeding connected load. I'll show that. Metering part.
So what I'm asking is the same thing. Same regulation.
One thing should be different. I'll just,
No, it's the same regulation. Maybe there may be some amendment
by and large, same.
or different.
By and large, same. Yes, it is there. In 2007, I can point it out.
Which one you are relying?
2007.
Seven.
Same.
Why then 2004?
No, 4 would also have it categorically. The earlier one also. 5 point.
There's a one same thing, but then
Same thing,
I mean the amendment or the different notification or what?
Put change. 5.3. 5.3.
5.3 I've seen, sir. What I'm trying to
Whether some changes are there.
why you are relying these two
I like
differently?
these two because to bring that.
If this is the same, notification may be different. There may be some amendment.
Because the earlier one I need to read of 2004 as to what verbatim what was there on the change factor. It continued through.
That is not here.
It is there, may I read through?
Ah.
Should the consumer at any point of time after the supply of energy has commenced desire to increase the number or size of lights, fans, motors, etc. in his premises or in any way alter the position of his wiring therein?
Extension and alteration.
That's it.
Yes.
Should the consumer
Yes. Then
at any point, at any time, after the supply of energy has commenced, desire to increase the number of or size of lights, fans, motors, etc. in his premises or in any way alter the position of his wiring therein.
Sir, I have understood this. What I am not understanding is that why you are relying in both this 2004 and 7. Where is the same? This regulation is the same. Regulation is 2004.
My lordship.
Why you are giving, placing two different.
I was under the impression that is Assam Electricity Regulatory Commission.
Same.
Supply Code Matters Regulation 2004.
Same.
Well, I got the point.
So you have relied some other thing.
No, I relied on that only.
Some other
that part even. Same part. Extension only. Extension wire.
No, there you have
Yes.
marked some regarding.
This is extension and relying. This part.
Huh?
I think, which is there also.
You are not relying that one?
It is the same thing there, 2007 minutes. You cover up. Extension in wiring, only that
There
part.
was some mark question.
This part.
No, not that. That I have seen.
Nothing.
That. Which has been marked.
2007 would have the malpractice as also of this one, extension wiring.
Yes, yeah. 5.A.4.
Look, I can't do that. I will open this.
Is there? 5.4. 5.A.4. 5.A.
Five point 8.3 and 5.8.4 of the regulation 2004, the first amendment came in 2007.
No,
That is how this comes both.
Therefore, this is not there.
Therefore,
It's not here.
it's not there, but
2004
the amendment
is
will
not
come in.
there.
That's what.
We'll rely this, not that. That's all.
It has to be that way. So what could be the solution without going into blame giving any parts? If as on date, because a lot of time has passed. If as on date, the stand of the respondent is that we had always maintained 425 and below till date, because there is no notice to us for increase. So it has to be invariably, it's 425 and below. Then, if they are also not shying away from the fact that what was found during the inspection, those extra things were found, they say the calculation ought to have been different. The appellate authority, my lord, did not address this part of the matter. That invariably, this would give rise to, however slight it might be, a raise in the connected load. It's not on mathematics. It's on the finding of those things there. It's not on the permutations in what combinations they were done, what could have been the output? No. If the things were there, and in absence of changeover and etc. at page 45, which the original thing was there is no denial to the fact these were not there. I say this apparatus is not there is one thing, and I say this was there, but you calculated wrongly is quite another. The moment I say it is there, I had no business of it to be here if the original connected load was 425. Therefore, not only the respondent failed to satisfy or discharge his burden, but the very fact that we are not put to notice and an inspection team requested 10 times, kindly give us these things.
Where is the power and the procedure of the appellate authority before the authority? Appellate authority.
Well, the appellate authority would be under 127 of the Electricity Act.
Electricity.
This would
127.
127.
Appeal to the appellate authority.
May I read? Any person aggrieved by the final order made under 126 may within 30 days of the said order prefer an appeal in such form, verified in such manner, and be accompanied by such fees as may be specified by the State Commission to an appellate authority as may be prescribed. No appeal against an order of assessment under subsection 1 shall be entertained unless an amount equal to half of the assessed amount is deposited. Such deposit has been enclosed along with the appeal. The appellate authority referred in subsection 1 shall dispose of the appeal after hearing the parties and pass appropriate order and send copy of the order to the assessing officer and the appellant. The order of the appellate authority referred to in subsection 1 passed surrender shall be final. No appeal shall lie against the appellate authority referred in subsection 1 against a final order made with the consent of the parties. When a person defaults in making payment to the assessed amount, he, in addition to the assessed amount, shall be liable to pay on the expiry of 30 days from the date of the order of assessment an amount of interest at the rate of 16% per annum compounded every 6 months.
Yes.
That's all. That's all. So there needs to be a revisit along with the apparatus, which is admittedly there, but they say the computation was wrong. They did not use it whatsoever. It ought not to have been there in the first place.
Can it be possible now?
Yes, because they had not denied
This
it.
was when inspection was when?
6th of March 13.
2013.
It is not only consumption. That's what I say. They have not denied the presence of the articles. What they are saying is that the computation is wrong. If you have the articles and for a particular purpose, then it was only meant to be done for going.
So they are not denying the presence of the apparatus, but the computation they are trying to dispute.
That's my case. You ought to have put us to notice. Things should have gone because otherwise it's below the sanction load also. Obliged function.
Yes. Yes. Please use the mic.
My first point is this, Lordship. This writ petition is not maintained. First point is this, your Lordship, that petitioner is a limited company, your Lordship. And its name itself indicates that it is a company or some power distribution company. So a company, private limited or limited function under the provisions of the Act of the Company Act, Your Honor, earlier 1956, now Act of 2013. So every company, Your Honor, Lordship, if wants to file any litigation, Lordship, first of all, the board of directors of the company pass a resolution, Your Lordship, that such and such person, chairman or MD or anybody has been authorized to initiate the proceeding, Your Honor, against such and such person. That is the mandatory provision, Lordship. That is my first submission, Lordship, that in view of this, because in the writ petition, your lordship will find funniest things that just your lordship will be pleased to take up the cause title of the writ petition lordship. Your lordship may come to page 3. Page 3 of the writ petition lordship.
Yes.
Page 3, your honor, lordship. The Assam Power Distribution Company, represented by its chairman cum managing director, Bijli Bhavan, so and so, so and so. So, and see the affidavit. Affidavit at page, lordship, page 20. Here, lordship, the affidavit has been sworn by one Saiful Nur Ahmad. And in para 1, he has stated that the Assam Power Distribution Company Limited is a petitioner in the instant misapplication. Lordship, may please to note whether writ petition will be a misapplication here, lordship. Under 226, your lordship. And I am presently serving as Assistant General Manager Law in Assam Power Distribution Company, lordship. Bhavan near Guwahati, and I have been authorized by the petitioner in the instant writ petition to swear this affidavit on behalf of the, and I am fully acquainted, lordship. Lordship, in the cause title, the chairman is representing the company, but there is no resolution in his favor by the board of directors of the company as required under the section 179 of the Companies Act, lordship. And same provision was also in the Companies Act of 1956, lordship. And affidavit, lordship, is defective one because the person who sweared, he is not a party to the writ petition. He is a law officer. He has been also not authorized by the board of directors, lordship. And this point of law is well settled, lordship. Without a company does not have the eyes and ears, lordship. The company functions through the decisions, resolution passed by the board of directors of the company, lordship. And this law is well settled in the Bank of Travancore versus Eagle Kingston Computer Private Limited, lordship. This is the judgment of your lordship and 2011 law. Here, the fact of the Supreme Court judgment was this, lordship, that the MD of the company authorized one of the directors to represent the company, lordship. But that authority letter was not passed by the board in a resolution by the board of directors, lordship. And then the matter went to Supreme Court, and then your lordship may come to the last page, para 14.
Yes.
Para 14. Last page, lordship, part of, in our view, the judgment and the challenge is liable to be set aside as because the respondent had not produced any evidence to prove that Sri Ashok K. Shukla was appointed as a director of the company and a resolution was passed by the board of directors of the company to file a suit against the appellant and authorize Sri Ashok K. Shukla to do so. The letter of authority issued by Sri Raj K. Shukla, who described himself as the chief executive officer of the company, was nothing but a scrap of paper because no resolution was passed by the board of directors delegating its power to Sri Raj K. Shukla to authenticate another person to file such suit on behalf of the. In the result, the appeal is allowed, the impugned judgment is set aside. So only your lordship, because the board of directors has not passed any resolution.
Maybe correct, but then it's a filing of the suit. Filing of writ petition is something different. Because as per the High Court rules, anyone who is authorized and has the knowledge of the matter
who is authorized
can file the writ petition.
Letter.
And so far as instant misapplication is maybe a case of copy paste, what do you call it, syndrome.
After appeal. Appeal
review, read.
No. Copy-paste syndrome. Why do we say instant misapplication?
Oh,
Should be read petition.
No,
Copy-paste.
the typical or
Yes.
slip of pen or mind, I am not so on that point.
Yes.
But humble submission, Lordship, the same principle will apply, whether it is a suit or a company, Lordship, or a writ petition, Lordship.
So it's a
Because the board of directors.
there's no authorization.
Yes, there is no authorization. No authorization letter has been filed. Even if there is no authorization, because the chairman or managing director lordship function as per the decision of the board of directors. And if the board of directors has authorized the law officer of the APDCL, there should be an authority letter. Then only the writ petition will be, otherwise in a company matter, everyone will come to court without having a resolution from the board of directors and file the case, lordship. The company cannot face such situation, lordship. That was my. Apart from that, my second submission is this, lordship. All the facts are the disputed facts. As pleaded in the writ petition, lordship, almost all facts are the disputed. The petitioner is saying that there was excess load. The respondent is saying there was no excess land load, and the even interesting, lordship, when the appeal was filed before the London Appellate Authority under Section 127 of the Electricity Act 2003, lordship, a point was taken that the chief vigilance officer, who was the retired IPS officer, was not a qualified engineer. And as per the government circular, lordship, only a person having the status of the minimum executive engineer in the electrical branch, lordship, can be appointed as a vigilance officer. Then your lordship may be pleased to come to the, take up the page 161 of the my affidavit in opposition. My affidavit in opposition, where this is clearly
61.
page 161.
161.
Page 1 of the affidavit in opposition. Lordship may come to page 161, para Roman 6. For that the mere perusal of the inspection report dated 6/3/13 is transferred clearly that the assessment bill of the alleged connected load has been prepared determined by the respondent number 6, who happens to be an IPS officer and not having technical expertise of electricity, and further he is not the authorized person to make an assessment of the power supply, on the basis of which the alleged provisional assessment bill dated 12/3/30 was prepared. As per the notification of the Government of Assam, Power, Electrical, Mines and Minerals Department dated so and so, and for acting as an assessing officer, he must not be below the rank of the executive engineer. In that view of the matter, the entire alleged proceeding are void ab initio, nullity in the eye of law, and liable to be set aside in past. This vigilance officer, lordship, he was a retired IAS officer. He was not even a junior engineer, lordship, or is it even diploma holder in the engineering education, lordship.
His status is much higher than the
Yes.
status is much higher than the junior engineer.
No, that is correct, but one should have the technical.
What is the requirement of technicalness as per?
Because lordship,
Assam Power, Electric, Mines and Minerals
Government of Assam notification, lordship.
Power, Electrical, Mines and Minerals Department.
The vigilance officer must have the executive engineer qualification, lord. Then only he or she can be appointed. He had no even requisite qualification.
Vigilance and the assessing officer is different, same thing.
Lordship.
The vigilance officer and the assessment officer one and the same?
One of these, it's the same, lord.
He said.
If chief vigilance officer is different, vigilance officer is.
No, I'm not asking chief. Vigilance officer and the assessment officer, the notification you're relying is about the assessing officer.
Assessing authority is the area manager. Area manager of the revenue electrical APDCL. But the chief vigilance is done under the supervision of the vigilance officer who must be a qualified electrical engineer to the level of the.
Where where does it say? Where it is? Where is the requirement? Under which notification? Under which rule?
This is not, I have already, this is the notification lot.
That's why I'm asking, sir. This here in our case, the present case, it's a business officer. Is not it?
Yes.
The para 6, this notification talks about the assessing officer. That's why I'm asking whether the assessing and the business officer one and the same
In
thing.
the present case, Lordship, he has assessed the Lordship, may be pleased to para. For that on merit appraisal of the inspection report that is transferred clearly that the assessment bill of the LS connected has been prepared and determined by the respondent number 6, who happened to be an IPS officer. Respondent number 6 is your Lordship in the request title.
Is a business officer or assessing officer?
Just a minute. Thank you.
Chief business officer. No.
So 6 is the area manager. 6 is the area manager. Chief Vigilance Officer is Lordship, respond petitioner number 2, Chief Vigilance Officer.
Who has
And the respondent number 6 is the area manager who prepared the assessment.
area manager?
Area manager, and the petitioner number 2 is Chief Vigilance Officer is Lordship, who was the retired IAS officer. Lordship. And the bill, Lordship, may be pleased to peruse the
Business officer, chief business officer.
Yes.
So that's why I'm asking, sir, if you are relying on this notification, is the chief business officer and the assessing officer under the notification which you have relied on, is they one and the same?
No, different. Two different posts.
So why you are relying this? This is for
I am
assessing officer.
If the inspection was done under the supervision of the Chief Vigilance Officer, that is the petitioner number 2, who was a retired IPS officer, Lordship, whereas the notification provides that he must be to the rank of the executive engineer, Lordship. And your Lordship may please the inspection report.
And for acting as an assessing, that's why I'm asking, sir, vigilance officer and the assessing officer, one and the same, or they are different officer?
Assessing authority is friend, that is the respondent number 6. And
so it has to be by the, not below the rank of executive engineer. So who has done that? Who has done the assessment?
Bill assessment, Lordship, whenever a excess load is found or theft of electricity, then the vigilance cell visits under the supervision of the Chief Vigilance Officer, Lordship. And whenever the Chief Vigilance Officer submits a report to the area manager, Lordship, he prepares a assessment bill. That is not disputed, Lordship.
So area manager is the assessing officer.
Yes, here respondent number
He is the assessing officer.
Assessing.
So according to you, since area manager is assessing officer, he should have been, he ought to have been not below the rank, having the not below the rank of executive engineer.
Chief Vigilance Officer, he must be to the rank of the executive engineer, Lordship.
Kindly read it. Let us read it once.
Yes, sir.
Again.
So there are some typographical mistakes. For that, on perusal of the inspection report dated, transferred clearly that the assessment bill of the LS connected bill has been prepared and determined by the respondent number 2, who happen to be an IPS officer and not having technical experience of the electricity. This is a error on my part, Lordship, because this was done by the respondent number 2, Lordship, petitioner number 2, not by the area manager. This is averments are not correct.
Then
the averments are not correct, but actual position
if it is not correct, how can you rely on it?
May please to consider factual, Lordship. lordship, maybe the.
I understand you are very, you are fair enough, you are very fair. But then if it is not correct, how can you rely on this? Are you relying on the incorrect statement?
No, I cannot. I should then amend the petition, affidavit in opposition lordship. But here, but factual position is same
No,
lordship.
okay, I've understood. You are fair enough. Come down again. Is not authorized person to make an assessment on which a list provision assessment bill as per notification. You read from here.
Yes. As per notification of the Government of Assam Power Electrical Mines and Mineral Department, dated 29/11/24, and for acting as an assessing officer, he must not be below the rank of the executive engineer.
So,
in that view of the matter,
no. So for that, therefore, the respondent 6 who has assessed is not a competent person because he is not an executive engineer.
No, look, area manager, here is a typical mistake, I must admit. Area manager is generally appointed who are of the rank of the executive engineer. Here there is a mistake, Lordship. Because your Lordship, assessment, area manager prepares the assessment bill, Lordship, for overload or theft or malpractice on the basis of the report.
Of the business officer. Chief business officer.
Yes, prepare and reported by the vigilance officer to the area manager.
Sure. So who is the area manager?
Area manager is
Respondent number 6.
Lordship.
Respondent number 6 is who has assessed the bill?
Who has assessed the bill on the basis of the report submitted by the chief vigilance officer.
So what's wrong? He is equivalent to the executive engineer.
No. My submission is the person who visited on the day of inspection, Lordship, in the capacity of the chief vigilance officer. He ought
not
to
as a area manager.
No.
It ought to be the area manager.
Area manager just he prepares the bills on receiving the report from the.
No. According to you, it ought to have been a area manager, not the chief vigilance officer.
No. The vigilance officer ought to have the requisite qualification of the executive engineer in electrical.
That's what I'm saying. And for acting as an assessing officer, he must. Who is the assessing officer?
Assessing officer is the respondent number 6. Sorry, petitioner number 6, Lordship. And vigilance officer is petitioner number 2.
Who has acted as assessing officer?
Assessing officer, area manager.
So what's wrong there? So it says that he must not, and for acting as an assessing officer, he must not be below the rank of executive engineer.
There are mistakes. Mistakes are there, I must admit, Lordship. This para would have had to be casted. The chief vigilance officer who visited.
Who acted as an assessing officer?
No. He ought to have it. Line would have been like that. He submitted the report to the area manager, and on the basis of the report received from the chief vigilance officer, the area manager prepared the decision. So the report submitted by the person, that is chief vigilance officer, he had no requisite qualification of an executive.
It is not required. Only the assessing officer is required to be below the rank of.
Area manager never goes along with the vigilance team, Lord.
Achha.
Vigilant team's Lordship, may please to pay the instruction.
So who has assessed the bill?
Area manager.
So what's wrong?
Lordship, I am not saying that the bill is wrong and that I will come to. Bill is wrong.
Bill is correct, then what remains there?
Bill is not correct, Lordship. My submission is this: the chief vigilance officer.
Yes.
Who had inspected the factory premises, Lordship, had no qualification of the executive engineer electrical department.
That's why I'm saying. For acting as an assessing officer, who has acted as an assessing officer?
I have already admitted, Lordship, Para has not been casted in a proper way. Not casted in a proper way. Your Lordship, please do the.
So we'll not rely on this. This paragraph goes. Abandon.
Inspection report lordship.
Stands struck off.
No.
This paragraph stands struck off.
Struck off also is there. That is your lordship power.
Not my
But,
power. You say this has not been properly.
I will file an application for amendment also. Amendment also. Lordship, may we come to the inspection report, Lordship.
Sir, come to the merit.
Merit.
Let us come to the merit. Huh?
I am merit.
Yes. You are
Lordship has perused the an application.
technical, you are saying that the writ is not maintainable because it has not been authorized by the company by way of board resolution. Number two,
all questions are
all disputed question of
disputed,
facts.
so that cannot be tried in a writ.
By whom?
By this honorable court or
It's a too common, too elementary.
when all these, your lordship will, I'll
See, then how do we examine the order of the appellate authority?
petitioner.
Why writ is?
Writ petitioner lordship was.
Are you saying that the writ will not lie against the order of the appellate authority?
Because the section 127(4) itself provides that
What?
the decision rendered by the appellate authority shall be binding. Lordship, may please to pay.
That is the whole problem, sir.
127(4).
Therefore, 226.
Yes, sir. I know, Lordship, that.
That's why if you know, then what's even
maintainable.
there's no further appellate authority.
That the appellate
Act
authority order will be.
It's a final. Therefore, writ lies under
lies.
226.
It lies, but Lordship, the jurisdiction of the writ, your Lordship very well heard that it has some restrictions. When the questions are disputed, Lordship,
I understand.
and when the court does not have the expertise to decide the technical matter, in those cases, Lordship, the writ will not be maintained. And as because the petitioner had the option to file a civil suit for realization of the money, Lordship, against the order of the Lordship, the appellate authority. They had.
So therefore, according to you, I'm asking again and again, writ would not lie. Writ would not lie against the order of them.
I'm not saying writ will not lie.
Okay.
But writ will lie, but there should not be disputed question, Lordship. And if even there are some disputed question, but if the disputed.
That's why I specifically pointed out what is wrong in the order of the appellate. It's a jurisdiction error.
No, there is no jurisdictional error. Lordship.
You may say so, but
Because
he said so.
Because the learned appellate.
You may argue on that.
Lordship, one point, this is a frivolous petition, Lordship, and based on totally falsehood. I can prove that on the basis of the averment made in the writ petition, Lordship.
Yes, you prove it.
Yes.
Some other day. Mr. Roy might have a little exhausted today.
Yes.
Can we continue tomorrow? And in fact, except for this technical thing, I think you don't have other case, no other grounds to argue.
There are many of them. Their notification, Lordship, whatever notification my learned friend has placed before your Lordship, almost they have been repealed. And apart from that, nowadays, Lordship, when the digital meters.
One by one, sir, one by one.
Digital meters are.
One
fitted.
point after another.
Digital meters are fitted, Lordship, whether it is for domestic or commercial or for industry purpose, Lordship. Then, if there will be any excess land or load, then the sanction load, Your Honor, the meter will show. Because one meter is provided inside the factory premises and other meter is provided along with where the transformer from where the electricity connection is given. So that the meter where it is installed along with the transformer, Lordship, records A to Z things, Lordship. And if there is any excess load, that meter will, both the meter fitted in the factory premises and the digital meter fitted along with the transformer, Lordship, will show that their sanction load is this, and actually the consumer is using this much excess load laws. These are rules and law and apex court judgment, then various appellate authority judgment I am having all. This may be taken.
No. Please show us. What is the judgment?
Yes. This may be taken tomorrow.
No. We'll continue.
Now, Your Lordship, may please to come to.
Are you comfortable, Mr. Roy? Sir, are you comfortable arguing the matter? Because we will have to see. It's been whole day. If you are really exhausted, because it should not have any. Have any effect to your health. I find that you are not that comfortable.
Anything.
Because
He's senior member.
you definitely will not be able to complete today the way you are trying to argue the matter. And it appears that you are not comfortable today.
No.
Appears to be little exhausted. Mentally or
Both mentally, physically. I am now
physically.
70 years old.
No, that's why. That's the reason. We'll have to have that kind of. That's why I'm saying. Let us be very frank. If you are not comfortable, it's okay. No issue. Heaven will not fall if you don't complete today. All right.
I leave it.
Tomorrow when?
Tomorrow, even I am ready to do first half.
Then we'll keep it Thursday. Hearing day.
Hearing this.
Only your part he has completed. Please be little specific. Sir, you assist. You are the instructing counsel. Madam, you assist her. Assist, sir. You take his advice, both of you, but then be little, precise. Not here and there. Point wise. Sir, you just tell them, just dictate them for a little, spend some minutes. Dictate them the bullet points, 2-3 points which you would like to, and then you just argue on that. I'm not supposed to give this, but this is convenient of the court. Not for you at least.
Synopsis.
Not synopsis. I want that the point which you would like to make should be in seriatim and in a precise manner if it is possible. We cannot stop the lawyer to argue, but then certain areas we need to stop also. In certain after certain time and the situation. Is not it?
Only.
And for that we need your cooperation. Particularly, we would like to learn, and the juniors would like to learn from the seasoned senior lawyers.
Our duty is to assist the honorable courts.
Yes. So little specific and to the point, so that this court can understand. Until unless I understand, I will not be able to deliver justice. Anyway, I heard Mr. S. Manik, learned counsel for the petitioner. Heard the matter at length as prayed for by Mr. S.B. Roy, learned counsel for the respondents. Let this matter be listed for further hearing on Thursday, 4th, 040920.
Heard in part.
Huh?
Heard in part.
Heard in part.
Heard in part.
Otherwise it will be not proper.
Like, grateful, obliged.
24.
Well, this is one part of matter.
May praise the Lord.
Yes.
Lordship, my senior will not be argued the case today. Lordship may kindly fix it after Puja vacation.
Why?
He has had personal difficulty.
There's no time also.
Can it be on 18th?
18th of October.
18th October.
Okay.
1800?
Is prayed for by
18th of this month, not October.
No, MS
K. Bora.
K. Bora, learned counsel appearing on behalf of Mr.
S. Datta.
S. Datta,
Senior advocate.
senior advocate. This Surajit or Shishir?
Sishi Datta.
Oh, yes, that for the petitioner submits that her senior, Mr. Datta, has some difficulty today, therefore prays for listing of the matter after 4 weeks. Will not say after vacation. As Mr. S. Chakrabarti, Learned Counsel for the respondent, that raises no objection, let this matter be listed after 4 weeks as prayed for. You give take the date after 4 weeks.
Can it be on 18th of September, the hearing day? Otherwise,
18 will be.
Senior will not be able to.
So the same thing will happen.
After
So
vacation.
safer side, you choose a date for after the vacation.
Lordship,
14 October is also there.
16
14th of
or
October.
17th, Lordship.
14th October.
Ah,
14th
you agree to that?
16.
14th
Yes.
October. Every time 18 not available.
You decide yourself.
14th of October.
16 October, he was saying. My senior was saying that he can.
Okay, you are since you are there and senior will be appearing to make it 16. 16. 16 will be better. It's a matter of 2 days. 2 days.
I think 26.
Yes.
My lord, this matter also, my lord, Mr. Nayak was here, my lord. He was.
No, we'll finish today. Yes.
My lord, he just left, my lord.
Call him.
He's left for the thing, my lord. It was a positive, I already spoke.
No, it's already, this is a part of better.
I can have it on some other day, man. Any day, man. Some other day, man. Because he was here, man. Then he saw that other matter, 2 matters, the other council said they.
God, see, every day we have different cases fixed.
I don't have it.
So it's become very difficult to have this case management.
One day.
To manage the case is very difficult now, if this is the cases. We have heard you, I'll decide the matter.
Have it on some other day. Mr. Nayak will be there, my lord, and Lordship will have it at 2, my lord. Any day, my lord.
When?
2 p.m.
Any day, my lord, Lordship, in the next week, my lord.
When?
Any day.
Any day
Next week, my lord.
Why 2 p.m.?
2 p.m. because then, my lord, it will be fixed.
Then will
No.
will be available.
No. When we can be available every day, why not?
Next week.
Next week or any day.
Next will be heavy, na? Anyway.
Hearing day. Any hearing day.
Tuesday lower day.
9 will be convenient.
As prayed for by Mr. Efukon, Learned Counsel for the respondents. As a last chance, let this matter be listed on 9th.
9th of September.
Mr. So-and-so, Learned Counsel for the petition is present.
Keep your blessed.